it really would be impossible for this case to be tried prior to the election in November.
And former President Donald Trump is actually right now in New York. We've been told from reports for another court case or court hearing, I should say, that is not connected to this. So there was talk on the internet about whether he would make an appearance, whether it is to just create a conversation around this, give this more attention, or just the personal satisfaction maybe of sitting in the room for a hearing like this. But we are told from reports that he is actually
good morning
making an appearance.
We are watching live
really
whether Fani Willis is going to be disqualified.
As we take a look, that's another one
from the Trump case. Now, if she's disqualified, this case is essentially over. So this is a big day for the Trump Georgia case. Good morning, everybody.
Charges.
Hey, good day. No, I haven't live streamed in a while, but I was happened to be up, happened to be free, and I was like, hey, let's see if Fani Willis makes it through today.
But he does have a reason to be in the courtroom in New York City, as he is facing charges there
Trump said he was going to make it here, but then
hush money payments, alleged hush money payments made to a former adult film star, and that trial is going on, and he is in.
Hey, good morning, everybody.
He was scheduled to be in the courtroom for that. So, he's got a number of different cases and charges in a number of different jurisdictions.
So, for those of you who don't know what's going on in this particular
is one case, the hush money case is another. And then there are the federal cases that the U.S. Justice Department is trying for. Those are charges related to his alleged mishandling of documents.
It seems like he was taking some of the money that he was making from the case,
Florida, and also his role in the January 6th Capitol riots. And so he is faced
during vacations and all this other stuff. So there's a huge conflict of interest, or even a perceived conflict of interest, or the appearance, as the judge said, the appearance of a conflict of interest could get her thrown off the case. Now, if she's thrown off the case, that case is not going to be dismissed, but it's going to be transferred to another DA's office. Now, most of the other DA's offices are pretty conservative, so I don't believe that that this case is going to last if it is removed from Fani Willis. So she is now, for no matter what you think, I think political career is on the line here with this hearing. So for those of you who don't remember, a couple of days ago, the judge said that there was enough evidence to have this hearing, number one. And number two, that even the appearance of a conflict is good enough to get the case removed. So what evidence do they have? They have a ton of evidence. That ton of evidence is the plane tickets, all this stuff. So here's the judge. The judge is coming on. He knows this is a big day. Let's see.
So we're going to take you out
what's
now.
What's going on? I see people from UK. Thank you. From South Africa. Hey.
23 SC 1889.
Here we go. Let's see if Fanny's going to make it.
Defendant Roman's motion to dismiss and disqualify filed January 8th, adopted and supplemented by several co-defendants. So first, if we could have counsel for the record identify themselves, starting with the state, and then we'll go through the defendants in the listed order. So
500K, yeah, 500K.
Anna Green Cross for the state.
Good morning, Judge. Adam Abadi for the state.
Good morning, Your Honor. Andrew Evans for Nathan Wade.
Here he is.
All right. And beginning with, from the order of, on the notice, beginning with former President Trump.
Good morning, Your Honor. Steve Sadow and Jennifer Little.
Oh, Trump's attorneys are there too, so they've joined in this.
Sadow. On behalf of Mr. Giuliani.
I gotta feel bad for Jenna Ellis because she pleaded, and now the whole case could be thrown out. It's like all those people who pleaded guilty. Yeah, if this is thrown out, that's how they feel.
And let me go back to Mr. Durham. Mr. Durham, does your client also waive his presence as well?
Yes, Your Honor.
Okay. Did I catch that from Mr. Giuliani?
Yes.
Okay. All right. On behalf of Mr. Chiuli.
Richard Rice.
Sorry if it's hard to hear, but they have bad mics because
on behalf of Mr.
not on the
Roman.
mic, so I'm too loud. I'll move it down.
Mr. Schaefer.
Good morning, Your Honor. Craig Gillen and Anthony Lake for Mr. Schaefer. Mr. Schaefer is present in court.
And Mr. Floyd.
Aaron McCullough on behalf of Mr. Floyd.
And then we also have Ms. Latham.
Good morning, Your Honor. William Cromwell for Ms. Latham. She waives the presence.
And did we get that, Mr.
Okay.
McCullough, also as well for Mr. Floyd? Just making sure. Okay, thank you. Oh, Mr. Floyd is here. Okay, I see Mr. Floyd.
Just so everybody understands, all of the attorneys for the
All
defendants
right.
are there because they all of them are jumping on this. They're like, yeah, we want her disqualified.
All right.
So there's a whole there's more attorneys here than a law school.
Anyone else present who believes they may need to be on the record or address any issue coming up in the proceeding? Seeing none.
Judge, I'm here, Dave Banks. I've been subpoenaed as a witness, but I also represent Christopher Campbell.
All right. Thank you, Mr. Banks.
Judge Ben will chauffeur for Terrence Bradley. We're under subpoena. We'll be waiting in the hall.
All right. And sir, could we have you spell your name for the record?
First name Bimal, last name Chopra.
This is actually happening. Wow. All right, so these are, who's
All right,
here?
in terms
Who the hell's
of
here? These
just
are
a
the people.
little housekeeping in terms of presenting the evidence this morning, my thought was, as witnesses are called, this being Mr. Roman's motion, that counsel for Mr. Roman would be the first,
Yeah.
and any
Prove your
witness that they
case.
call, then in order of the listed defendants, there would be the opportunity for additional direct or cross-examination, however you want to characterize it, and then the state on the tail end of that. So
Oh, this can go on
with
all day.
that, I would turn it over to Ms. Merchant. Is there anything that we would need to take up before calling the first witness?
Judge, we would invoke the rule of sequestration.
All right. So to that end, pursuant to Rule 615, I would ask that any witnesses subpoenaed or expected to testify at the hearing today, that they should
They gotta
remain
leave, right?
outside the courtroom
They
until
gotta
called.
leave.
And they shouldn't discuss their testimony with any other witness or watch any kind of live proceeding or recording of the testimony until the evidence is concluded or they're excused from being called today. Are there any exceptions to this rule?
None of mistake.
Any from the defense?
No, thank you.
Okay,
So that
Mr. Abadi.
all the witnesses who are going to testify, they can't be inside the courtroom while things are going on.
Address, I guess, housekeeping matters in issues to the court as relates to what was represented during the previous hearing, as it relates to witness testimony, specifically the testimony of the former law partner of Nathan Wade, that would be Mr. Terrence Bradley, and what the state would like the court to understand and realize is that in preparation for this hearing, and speaking to witnesses and doing the additional research as relates to the comments that were represented by counsel, specifically counsel for Mr. Roman, Ms. Merchant, that we've been able to determine that the claims that the defendant has.
Oh, thanks for the
asserted
memberships. Here we go. Thanks for becoming a member.
Monday are not only
Thanks.
legally meritless, but are factually unsupported.
Thanks for giving the 5
by
memberships. I
the
appreciate that.
statements that Ms. Merchant made to the court. What I would say are they're patently
Fanny's
false.
not here.
They are egregious misrepresentations of what is believed that Mr. Bradley would say or even knows. What I would bring to the court's attention in my speaking with the defense counsel for Mr. Bradley, Mr. Chopra, is that any knowledge of anything he would have would be protected under the attorney-client privilege. He would assert that, and that privilege has not been waived.
I'm doing well. I'm doing well.
More importantly, the representation was made to the court that Ms. Merchant spoke to Mr. Bradley, and that Mr. Bradley represented that he had firsthand knowledge from speaking to the several witnesses.
Hey.
That he would be
Nothing
able to
yet.
keep
Didn't miss
statements
anything.
She represented that there was a relationship prior to Mr. Wade being appointed special prosecutor, and that there was issues with cohabitation that he would be able to directly impeach those witnesses. That is patently false. And speaking with Mr. Chopra, those
Oh,
are
thank you so much.
that are not true. They are for the purpose of harassment an undue burden to the district attorney, and we'd asked to renew our motion to quash. And the only hearing we should be having is the hearing as it relates to sanctions for the defense counsel's lack of candor that's required by not only statutory law, the professional rules of responsibility, and case law. And we asked that we move into a hearing that is related to the sanctions due to the misrepresentation and flagrant falsehoods that have been spread throughout the world in an effort to affect this case and to keep it from moving forward.
So he's saying that the defense is lying about Fani having a relationship before, and there should be sanctions.
Matter of housekeeping. Yes. Ms. Merchant.
Small matter.
Judge, first, the witnesses haven't been sequestered, so I just asked that they be sequestered before we argue this or any more argument. So we just asked that he leave.
In other words, there's some witnesses that are still in the room before they talk. Yeah.
Mr. Bonney.
Well, I would agree when testimony starts that the rules of sequestration would require Mr. Wade to leave, but that we haven't started testimony. It's his argument.
So Wade is a witness, so he should go outside.
Sitting at the table.
Okay, Ms. Merchant.
Let's hear from some witnesses. Let's actually hear some sworn testimony under oath. I have made proffers, and it just seems like all we're going to get is objection after objection. Because
Now remember, Wade is on record saying the relationship did start, and so there's a whole bunch of issues there.
And we need to have witnesses.
And he has to testify.
Learn I have a good faith basis, and Mr. Bradley is not my only witness to this good faith basis. It is just happens to be the evidence I proffered at the hearing when the state first tried to keep all of the other witnesses off the stand. I was forced to proffer certain testimony to get over the hurdle to refute their
Thanks. Thank you so much.
I did that. I used Mr. Bradley's testimony to do that. He is not the only witness.
Okay, so you guys understand what's going on here. Fani is saying that, hey, you guys are just making salacious allegations and you guys should be sanctioned. She's saying, no, I only have to have a good faith basis to make these allegations. And I do. Here are my witnesses. So that's what she's saying. Well, let's just hear from the witnesses, and then you could determine if we have overstepped.
Do we want to do it like I could stand up and grant relation what's just been said by Mr. Abate?
I'm trying to turn the court volume is at maximum. It's because everybody's so far away from the mic. Sorry about that. I'll try to keep quiet while they're talking.
Sure. So I think at this point, we just need to take these issues one at a time. And as you've joined the motion, I think defense counsel would have the opportunity to weigh in. But again, at any point, if I'm just hearing the same thing over and over again from each separate defense counsel, I'm going to reserve the right to say, thank you.
I appreciate that.
All right.
I only ask
Yeah, I'll turn down my mic even more.
location of the attorney-client privilege and the burden being on the individual raising the privilege should prove that a privilege in fact was in existence before we get to the claim. That's what I asked.
Sure. Understood. So, Ms. Merchant, I do want to put it back to you, though. The issue raised by the state this morning is that essentially, as I would summarize it, the good faith basis that you did put forward on Monday did not exist, right? So why wouldn't we start with Mr. Bradley and see where we go from there?
Judge, the good faith basis does exist. So you basically have them saying it's not true and me saying it's not true. So they think they have a good faith basis. I think I have a good faith basis. I have a huge good faith basis for everything that I put in every single motion. That's going to come out. The reason I don't want to call Mr. Bradley first is for hearsay objections, quite frankly. And normally we don't have to disclose how we're going to present evidence. I'm okay doing that here, but based on the rules of evidence, hearsay, and privilege issues, what makes the most sense, and we've spent a lot of time thinking about this, what makes the most sense is for us to have Ms. Yeardy testify. And if you want me to proffer what I anticipate she's going to say, I talked to her last night. She's going to say that there was a personal relationship that began in October of 2019. She's going to testify to that.
Woo!
And she has personal direct knowledge.
That's a good faith basis.
Not privileged. She's going to take the stand. She's terrified, but she's going to take the stand and tell the truth. And then I plan on calling Mr. Wade, because at that point I can overcome their motion to quash and bring Mr. Wade, bring him to come. Then I can go through privilege issues with him, and then I can have Mr. Bradley testify. And we won't have to have an objection to every single question I ask Mr. Bradley, an objection to hearsay, an objection to privilege. So that's how I plan on presenting the evidence, because it makes the most sense. And I think I'll be able to overcome any privilege objections. We can talk about that when Mr. Wade takes his seat.
All right, Mr. Abadi, any last words on starting with Ms. Yurden and going from there, taking it a witness at a time?
I mean, no, but I guess my final response would be that, as Your Honor pointed out during the last hearing, Ms. Merchant's entire representation.
It's the court audio. I can't. There's nothing I can do.
Solely based on Mr. Bradley. In fact, I remember the court saying that the star witness presented or provided by the defense is Mr. Bradley, and you asked a specific question, Ms. Merchant, well, Mr. Bradley, does he have firsthand knowledge from these people, each one of them, you named the lawyers plus the investigators, as it relates to the claims that were made? And her answer was yes. I can definitively tell you the answer is no. And Ms. Merchant has not spoken to Mr. Bradley, according to his counsel, B.C. Chopra, who is outside and can represent to the court the things that I've represented. And he has maintained and represented that everything that she plans to go into or ask is protected by attorney-client privilege. And the only point of this process and this procedure, as it relates to the motions that were filed, is to create a spectacle and to create harassment to the district attorney of Fulton County. And we request that the only hearing we move forward is sanctions for counsel's lack of duty of candor to the court and to counsel.
All right, well, I think you certainly put her on notice if that is actually the case, but at this point, I have someone saying yes, and I have another person saying no, and so I think that conflict in the evidence that we noted on Monday still exists, and that's where we are, and we'll see how the evidence presents itself. So with that, Ms. Merchant, are you ready to call your first witness?
Yes, Judge.
All right.
We called Ms. Yurden, and I know Mr. Partridge had emailed the court, and I quite frankly couldn't keep up about a Zoom, so I don't know if she's on Zoom or if she's here at 9:30. She may be on Zoom, I'm not really sure.
Ms. Partridge, Mr. Partridge was joining us by Zoom, but Ms. Yurden is here in person, right?
Mr. Partridge, I believe, represented that his client would be more comfortable if he were here in person, and that, due to his conflict in Richmond County this morning, couldn't occur until this afternoon. I think that is a reasonable request, but not the state's business. The witness is here. If her attorney is able to join right now, perhaps that can be something that is addressed with Mr. Partridge in the court. But I want to alert the court that that was the representation. The witness would prefer not to go forward without the client present, and that's certainly a reasonable request.
Sure. I think the latest I'd seen, though, was that Mr. Partridge was going to be able to join by Zoom.
People, so
I just know that he had
I'm listening
that
to
Mr. Partridge had.
But here we go.
But perhaps that was an email this morning that I missed.
I don't know either, but the state seems to know that Ms. Yurden is here, so I guess she's not here right now.
Is Mr. Partridge here?
We'll find out.
Okay, so everybody is up on the same page. The judge is saying we're going to go with the hearing. The DA is saying all this is nonsense and the defense should be sanctioned for bringing up these things because they didn't have any really good faith basis to make these allegations. The judge says, no, we're going to go through the witnesses and see if they had a good faith basis. And if they didn't, then we'll go through that. So right now, they're claiming, the defense is claiming they have a witness that's going to essentially say Fani Willis and Nathan Wade perjured themselves by claiming the relationship started after he was hired by Fani to do the Trump legal case. The defense is saying they have a witness that's going to say, no, the relationship started back in 2019, before the election, before any of this stuff happened. And if they can prove that, then they can prove that Fani Willis lied. Fani Willis and Nathan Wade lied under oath when they said the relationship started after.
Convey the Zoom link to Mr. Partridge this morning.
Everybody got that.
I think the last exchange we'd had is that he can join us by Zoom, and apparently is elected not to do so. So I don't really know what else we can do with that. He was noticed of the hearing. We provided him a link, and we haven't heard from him at all. So I think we need to go forward.
All right.
Your Honor, before we go forward, we have business documents that were certified and filed yesterday evening. Filed this morning, emailed to Fulton Council yesterday evening. We wanted to make sure that this was part of the record before any testimony was taken or before the proceeding commenced this morning.
All right. And so in your mind, this satisfies Fulton County's subpoena in this case?
Correct.
Okay. If you could hand that to Ms. Merchant and we'll take it from there.
Okay, and I don't know, I need to review what they submitted.
I have an original for the court.
Ms. Monroe, if you could just provide it to Ms. Merchant, and
Yes,
if you could just stay on call, we'll let you know if we need you again, okay?
Thank you.
All right. Were we bringing in Ms. Yurdy?
Oh, I'm sorry, I thought the state said that Ms. Yurdy was outside, that they'd seen her or something. So, may John step out. She's under subpoena to be here at 9:30. May I text her later?
All right, so we're waiting for the first witness right now. Did Trump end up showing up? No, Trump is in New York because he has something to do here. This one says, Nate, why is everything seemingly falling apart here? Let's talk about that real quick. So essentially, what the argument here is that Fani Willis hired her boyfriend. And by hiring her boyfriend, that generally wouldn't get cases thrown out. But when you hire her boyfriend and pay him over $500,000 to try the case, that's maybe an issue. But the issue that the judge has to figure out today was that when her boyfriend was taking her on trips, exotic trips around the world and paying for all this great stuff that Fani was receiving, did she financially benefit off of this prosecution? Now, if she did personally financially benefit off of trips and all this other stuff, then she is likely going to be disqualified, essentially ending this whole prosecution. So that's why this is happening. That's why this is happening now. If the judge finds that there's even the appearance of impropriety, Fani Willis can be thrown off the case, and that means her whole office is thrown off the case. So this is a huge deal in this particular at this moment. I thought it would be simple, regardless of the start time. If she had any kind of relationship, live, or it's been government, personal, then yes, you would think so. But you still got to prove your case. So that's what we're here for today, is because there's been allegations made. Those allegations, she said, this is the reason why I'm making these allegations. That's what's called a good faith basis. Here are the witnesses who are saying this, and they are here willing to testify right now to show that she had this relationship and that Wade and Willis are lying. Now, understand this, people. I think this is one of the more interesting pieces of this, is that the defense is saying they have witnesses that are going to testify that Wade and Willis are lying when they said the relationship started after he was hired. Their witnesses are saying that the relationship started before they were hired. So that's what this whole thing is going to come down to. When did this relationship start? And then we go to, well, if they did have a relationship, which is essentially given, if they did have a relationship,
straight to voicemail, he messaged and said he's taking the
she can't get one of her witnesses. So you see things are going on.
All right. Did he say where his client is?
Yeah.
All right. And this is was this a former or current employee of the DA's office? Okay.
Now this is now they have former employees and everything about to explain, like, hey,
I know that she did not want to come out.
So now she can't get one of her witnesses. So this is not going too good for them now, because now it's time to put up or shut up. And they said put it up, and they can't put the witnesses now flaking. So.
All right. Well, Ms. Merchant, do you have any other witnesses available?
Well, we have Mr. Bradley. We have him testify, but again, we're probably gonna have a lot of objections with, privilege, and so I'd much rather call Mr. Yurden first, but I know that Mr. Partridge, threw a wrinkle in that this morning about
Thank you so much.
having a conflict.
All right.
Sure. So
But what I could do is I could call Mr. Bradley and then I can bring him back.
exactly, I think you can always recall them. We can ping pong back and forth if we need to based on
The witness
hearsay issues, but at least we can use this time until Mr. Partridge chooses to join us.
Is he on the Zoom? Or not Mr. Partridge or Miss Yurden on the Zoom?
No, not that we're aware of.
So their witness hasn't shown up. So now it's
All right, so
we got issues now.
I suppose call your next witness then.
So they got
All right,
to
call
put another
Terrence
witness on.
Bradley.
Thank you. Hopefully you enjoy with the coffee. Thank you so much, Fish. Thank you guys so much for the super chat. You don't know how much this really helps. So their first witness, their most explosive witness, ain't show up to Zoom, ain't there. So now we're moving on to a second witness. So we're gonna see.
If we don't hear, and I don't want to have the sheriff pick anybody up or anything like that, but if we don't hear from Mr. Partridge within an hour or so, we need to.
She's talking about having a sheriff go pick up her witness.
Understood.
Now.
Thank you.
This is not looking good. When your witness ain't show up, you built your whole case on this witness.
Is someone getting Mr. Bradley in?
Yes, I believe so. Oh, the sheriff's is on. Okay. Sorry. Normally, sorry. Are the sheriffs, when I call a witness, will the sheriff's not sound for them?
I don't know if they're going to know where they are.
Okay.
So I think it'd be best if maybe someone from your team, and they're not going to know what they look like either.
Not a problem.
Sure.
This is a disaster. This is a disaster. Now she's got to leave and go find the witness. All right. Well, Miss Willis is Miss Willis is the star witness in the room with us right now. Oh. Thanks, Nate. You're the best. Thank you so much. So just so everybody knows where we're at, right now, so we all know where we're at. The defense has witnesses that they claim are going to show that Fani Willis and these people were lying. They lied under oath. They lied about the relationship. They lied about it all. But that witness, for some reason, isn't coming. So they're looking for that witness. So, but she says she has multiple witnesses that can prove it. So they're calling a second witness who essentially was going to corroborate what the first witness was saying. But now they have to kind of do it in reverse. So that's why he's saying, okay, you can call the second guy, because the second guy is going to say more or less what the first. It's going to be a hearsay issue with the second witness, who they're calling now, is really relying on what the first witness is going to tell them, but now they can't get that first witness. That first witness is in the wind. So they want to send the sheriff, like you said. Can we send the sheriff to go get that person or whatever? They're trying to find that first witness. So things are right now not going good for the defense. But if what the defense is saying is true, it's possible that this case may be over today. So again, we're right now we're waiting. The second witness isn't showing up right now. So let me unmute this. Now, also, so we're all on the same page, Fani Willis's team, the prosecutor's office, has asked for the defense to be sanctioned because they said the defense didn't have a good faith basis. They're just making wild accusations without any good faith basis, any reason. But the defense is saying, no, we do have a reason. Here are these witnesses have told us this, so this is our good faith basis. So now it's time to put up or shut up, right? Show me those witnesses. And now the witnesses are supposed to show. They're not showing. So it's looking like, if you had a good faith basis, where's that at? Because there's no witnesses here. Why do you suppose the witnesses are flaking? One of them said they were afraid of, Fani Willis, and they're making, they're scared, and they're former employees and stuff like that. So I'm not sure why they're flaking, but that's what we're all waiting for. We're all waiting for the witnesses, right? She said, I have witnesses that are going to testify to this, and they're not there. Having McMuffin on me. Love your channel. A Latino for Trump from Chicago right here. Okay. Well, I know a lot of people are for Trump now in Chicago. I've been seeing the polls. I mean, I've been speaking to a couple of people who watch the channel from Chicago. Okay, so here's our first witness. Here he comes. right, let me turn this up so we can hear it. He's being sworn in.
Terrence Bradley, Terrence Bradley, Bradley.
Your Honor, as Mr. Wade's counsel, before we start, we would request to go back to the chambers to talk about attorney-client privilege before we get on the stand.
Why does that need to be in camera?
Doesn't necessarily, well, there's statements that could be made.
Hey, what's up?
That could be prejudicial depending on whether they were covered or not, whether he's going to break the.
So at the time a question is asked that you think implicates some of those statements, object, and we'll handle it.
Thank you,
Merchant.
Judge.
Judge, on behalf of Mr. Bradley, and I
They are
apologize.
trying to string this along forever.
It might be helpful to have a brief sidebar.
Don't say it in public.
Let the court know our position rather than having to state it repeatedly.
What are they doing?
And Judge, I've carefully crafted my questions to avoid any privileged information. But if they think that I'm invading that, then I welcome. an
Just so
objection.
everybody understands what's going on. They're trying to delay
Let's see how
this
it goes.
as much
And
as
again,
possible.
Mr. Bradley,
Let's go
I'll
to
ask
the
if you
back.
can just
Let's go to
give a
the back.
pause in between each question to allow counsel the opportunity to object before answering.
Thank you, Judge. Was the witness sworn or do I need to swear the
I
witness?
believe he was.
Great, thank you. I'm sorry. Good morning, Mr. Bradley. How
There
are
we
you?
go. Finally.
Not happy to be here, I'm assuming.
I am not.
I understand. Thank you for being here.
Thank you, brother.
Wasn't my
Thank you.
choice.
Right. You were subpoenaed to come and testify in this case.
I was.
But you and I have spoken previously about relevant facts surrounding Mr. Wade and Ms. Willis's relationship.
No, we have not.
We have not. We have not texted about those facts.
Through a third party, you were given some information. You and I shared text. Our texts were more so about my health, more so about if I was okay with what was going on, that I would not be, whether or not I was going to be subpoenaed or not, and that emphatically I would not have been sitting in this position as being called as a witness. So that's what my text chain show. So no.
That we've never talked about Willis and Wade having a relationship.
He's trying to
Not
be very
directly
careful.
you and I, no. We talked about my health.
Okay.
We talked about, as I stated before, other things, but not this, no.
Okay. Did you text me about Wade and Willis taking many trips together?
I object, well,
Mr. Brown, there's been an objection.
He's objecting to his own question. He can't object. He's the witness.
I haven't seen the text message that she's attempting to impeach the witness with. And two, he's made all of his representations that he's had zero communication.
He's objecting to his
relates
own
to
question.
the issues that Ms. Merchant continues to ask about, and that the only information that she has from him is through a third party.
This is crazy.
Ms. Merchant.
Judge, it's not hearsay. We've had these conversations. If I need to take the stand, I will. If I need to put my phone into evidence, I will.
So the first objection was to privilege on behalf of the state.
Oh, I'm sorry. I did not respond to that.
Sure.
Thank you, Judge. Privilege is only communications that are made in furtherance of legal advice. There's been no showing that whether or not they took a trip to California or took a trip, or that Mr. Bradley and I talked about that, either in person or by text, that's privilege. I'm not asking for any communications that Mr. Wade might have made to Mr. Bradley in furtherance of any legal advice.
All right, and Mr. Abadi, I believe
give it up to
is
that
the
boy.
one
That was
asserting
a
privilege.
damn
It would
good
be your
reply.
burden to show
That was
the
a damn
necessary
good reply.
foundation there. Is that something you want to voir dire the witness on or take up here on this specific question?
Well, no, I'd also object to foundation grounds. She's not
Oh, now
cited
he's
any
now he's
foundation
changed
that
it.
he would have any knowledge
She
of
crushed
what
that
she's
objection.
requesting he answer. His answers were he had no knowledge, and now she hasn't laid the foundation in order to continue to ask the same question over and over.
Ms. Merchant?
Judge, on behalf of Mr. Bradley, we do object. This falls under the privileges afforded under 1.6.
They are objecting like crazy. You got like two
attorney-client
questions
privilege
out.
is not something that Mr. Bradley can waive. Only Mr.
just understand,
regardless
Mr.
of
Wade's attorney
information
and
or
the DA's attorney are
being proffered
screaming privilege,
by
right?
the client.
He's
Mr.
he
Wade
was
would have to waive them in order for Mr. Bradley to continue to testify
Bradley was
about
Wade's
any of
attorney in
this
some
relationship
instance. So
until it's been established when that privilege
they're
should
saying this
have
is all privilege.
begun.
That's
Sure.
right.
And
Got it.
so far, though, I haven't heard anything about a relationship, about an attorney-client relationship, about a privilege ever attaching. And I think that's going to need to be established before we can actually determine the scope of it and whether this falls inside or out of it. So I think either Ms. Merchant can take the lead if she wants to, but my understanding was that generally has to fall on the person who's asserting the privilege.
Except for the attorney is not authorized to violate that privilege, or else he has in fact violated the bar rules. We could have an opinion regarding from someone in the state bar of Georgia.
All right.
That's why I thought perhaps the sidebar might be important.
All right, cool. I turned my volume up.
Well, I still want to kind of
hopefully
see
you
how
guys
we
can
can
hear me
go. So,
better.
Ms. Merchant, it sounds like you're going to need to lay a little bit more foundation to see whether this
Oh, no, nobody's winning.
Is going to fall under privilege or not.
That's not a problem, Judge. And what I can do, I was just told that Ms. Yerdy's in the waiting room. But I can, if the state wants to read my text, if Mr. Bradley wants to read them to refresh his memory, I have absolutely no problem with that. I have my phone here and they're welcome to do that. But I'll talk about some other things. And then maybe if they're going to have a lot of objections to privilege and hearsay, what I can do is I can lay a foundation with Mr. Bradley, get him off the stand, put Ms. Yerdy up, and then Mr. Wade so we can get through the privilege issues. That might make the most sense. Thank you.
The other witnesses showed up. There it is. So we're gonna have some fireworks here. All right.
All right. Let's talk about
Here we
something
go.
not controversial then. When did you and Mr. Wade first meet?
Probably 1998.
Okay. And did you all have a law firm together?
We did.
When did that firm start?
Probably, I think it was 2010. We started exclusively working together.
Yes, the
as a
first
firm,
witness is here
operating as
now.
a firm.
Okay. And were you all actually incorporated as a firm?
Not initially, no. He had, when I passed the bar and I hung with shingle in 2007, I think he had been practicing a few years prior to that. He had his own firm. We had two separate firms.
Okay. At some point, did you all incorporate though together?
We did.
Okay. Do you remember about when that was?
I do not at this particular moment, no, ma'am. I'm sorry.
Okay. Do you remember if it was administratively dissolved?
I've been made aware that it's been administratively dissolved. Yes, I left the firm around 2 years ago.
When did you leave the firm?
August of 2022, I think it was.
August of 2022. Okay.
It was either August or September of 2022.
Okay. August, September. Let me make a note. So in October 2019, were you all incorporated as a firm?
I think we were, maybe.
Okay.
Yes.
Thank you.
And when Mr. Wade filed for divorce November 1st or 2nd, 2021, were you all incorporated as a firm?
We should have been. I'm thinking that we were. Yes, ma'am.
So she's laying a foundation.
When did Mr.
How
Wade
do you know the
come
information that you
to
know?
you
That's what she's
to
asking all these
file
questions.
the divorce action in Cobb County?
That's privileged information.
The date.
The timing and the beginning of the privilege, I don't believe that is overruled.
So the timing was around 2018.
Okay.
And it was probably December of 2018. I remember it specifically because I was building a house, and I noticed that he wasn't wearing his ring. I asked him about it. I had invited him to the house because I was having a
2018, he stopped wearing his ring.
And he wasn't wearing his ring. I inquired about it. From there, we discussed what would happen. And we discussed the divorce and what would happen.
What would happen with the divorce?
What would happen over me representing him for the divorce and when he would want to do it. Yes.
So this is his lawyer for the divorce.
Well, my memory would be 2018 when he consulted with me about the divorce and told me what he would like to see done and when he wanted to do it.
So remember, 2018 is 3
you know
years
when Fani
before
Willis and Nathan Wade met?
she was hired. He was hired.
Specific dates, no. I know it was sometime at a conference.
Municipal court conference?
Correct.
And October 2019, if it's been represented in the state's pleadings before, that's when they met. Does that sound familiar?
If that's what they're saying, then absolutely. I know it was at a conference in 2000. I mean, it was at a conference. If you say it's 2019, I'll take you at your word.
Okay. So it was what you're sure of, though, is it was at a municipal courts judges conference
Yes.
when they were both municipal court judges.
Yes.
So it's fair to say, since she became the district attorney, she was no longer a municipal court judge. So it had to have been before that.
That they met?
Yes.
Yes.
And he was teaching a class at that seminar, as far as you know.
I'm going to object to this deleting at this point. That's not direct.
Was he teaching a class at this seminar?
To my knowledge, he was.
And was Miss Willis, to your knowledge, attending this seminar?
Your Honor, I'm going to object. He's no personal knowledge. He wasn't present at the municipal court training.
But they put it in their pleadings. Like, we are going to be here all day.
We are going to be here all day.
All right. If you can establish that he would have some personal knowledge, then that's a fair question. So if you just need to preface it with that, then that's fine.
Thank you. Are you aware of when their romantic relationship began?
Your Honor, I'm going to object. That relates to privilege. She says that he began representing Mr. Wade in 2018. He met Ms. Willis in 2019. That's clearly within the bounds of attorney-client privilege.
I think there's understood, Mr. Avati. So I think, Ms. Merchant, you need to qualify that question.
Thank you. I'm not asking you to tell me what Nathan Wade told you in furtherance of legal advice. Okay, so I want to be very clear. If he told you something, asking you legal advice, I'm not asking you about that.
Yes.
I'm asking about what you observed.
This is tough.
What you saw and what you knew outside of what he told you when he was specifically seeking legal advice. Okay.
This is too far.
Yeah, it's tough. I would object to. I'm sorry. It's just, think about this, people. A defense, he's a divorce attorney. About when you cheated on your wife, it's clearly within that privileged area. It's tough. It's going to be tough.
Violating the rules of ethics associated with his bar license.
So the way the question was phrased was just saying, what did he personally observe outside of the relationship, not involving communications? How does that fall within attorney-client privilege?
How does that fall within attorney-client privilege?
Whether we like it or not, when we have a client, there are a number of items associated with that relationship between attorney and client that come within your purview and that lead you to further action, lead you to further investigation, further questions, develop your strategy.
See, this is the question they don't want to answer. If he says 2018, 2019, Wade and Willis are screwed. So this is why they're arguing over this question. This question,
their relationship to remain privileged.
Ms. Merchant.
Judge, his observations are not privileged. That's not what the privilege law says. And I can read you the attorney-client privilege attaches where, and this is the law, this is the rule. There's an attorney-client relationship. The communications in question relate to the matters on which legal advice was sought. And the communications have been maintained in confidence, and there's no exceptions to the privilege. First, or number two, the second prong. This was not in furtherance of legal advice. That's not in furtherance of legal advice. What he witnesses as a human being is not in furtherance of legal advice. Unless, I mean, and if he witnesses them together, it would get rid of the attorney-client privilege because Ms. Willis is there.
Third party. Yeah, the third party. She's right.
Additionally, though, exceptions. We can go all day about exceptions to this. Fraud to the court, that's an exception.
Because he said one thing.
Mr. Wade, we contend, has filed a false affidavit with this court. That is fraud to the court. If this witness has direct knowledge that that is not true,
then that's a fraud.
Then that's an exception to attorney-client privilege.
She's on her money. She's on the money.
All right. Ms. Merchant, if you could re-ask that question again, qualifying.
The judge is like, all right, she's got it.
I think you qualified it as anything that.
Why didn't you hire this woman represent him? Like, what the hell's going on?
Those are any observations you made.
Who are horrible. She's like,
in my mind, the phrase the question would have included before December 2018 when this first consultation occurred.
Yeah, she's not playing. She's like, no, it's not perfect. 1, 2, 3. This is the reason why.
And Judge, I would just ask permission. We gave the state notice under 611 that all of these witnesses do not want to be here. They are adverse witnesses.
I understand.
Yes, so I'd like to have leeway to be able to cross them. Thank you, Judge.
Remember, these people didn't want to show up either, so they're adverse witnesses. She's good.
In
Really good.
you acknowledge that their relationship began in 2019.
I do not have knowledge, but again, I have consulted with the bar as late as yesterday at 4 o'clock. I am not here to.
Your testimony is that you do not have independent knowledge.
I cannot. I was advised by the bar that Rule 1.6 of confidentiality applies, and that I cannot reveal anything that I saw or learned. And that if the court is asking me to do that, that an immediate certificate of review should be asked. And so I'm not here to misrepresent to the court or to say anything inappropriate or anything. I am here because I also have a law license, and I'm not trying to lose that.
And so, Mr. Bradley, can you finish that thought? As saw or learned.
All right, Razor Band Studio.
Just period. Without qualification whatsoever.
Judge, I'm going to refer to what I was told by the bar, that Rule 1.6 of confidentiality applies, and that I would be asking for an immediate review by the Supreme Court.
Sure, but applies to what?
Any communications is what the person at the bar told us.
He's just refusing to answer.
Any communications? So like
he did not qualify.
If you talk to Mr. Wade, that's covered.
Well, Judge, I don't know. He didn't go into those specifics.
Remember, they're not talking about what he's.
This is
what he said. What did you see? Outside
I was sitting
of that.
there with my attorneys, and this was what was told to us: to state that Rule 1.6 applies.
He doesn't want to say. Remember,
and we gave them the scenario.
When did you learn
and this
about
is what they told us to do?
And Willis's
this is what
relationship?
I'm doing at this particular point.
Judge, we have no knowledge if the bar was aware of the affidavit that Mr. Wade filed, but that significantly changes the privilege. He waived the privilege when he put that in the affidavit, so that's one of the reasons I wanted to call him. That's a waiver. He put the relationship in the when the relationship started, and put the relationship in his affidavit. He put a lot of information in that affidavit that would waive certain amounts of privilege. So he disclosed this relationship. So basically, what we've got is Mr. Wade being able to say what he wants about this relationship, but then we're not allowed to ask questions to qualify that. So that's not how it works. They either get to admit it or they don't.
It's either your privilege.
We're just talking about a relationship, though. How does that open the floodgates to anything he's ever told an attorney during representation?
It doesn't, and I'm not asking him that. I'm asking for his knowledge. They were law partners, and as I go through the questions, I think he has knowledge of things that is not something that Mr. Wade specifically told him. I also think there's a fraud exception to a lot of this, even if there was a privilege, but I don't think there was for most of it.
Your Honor, but he's already
if there's a privilege, there's an exception.
I don't think we've actually gotten anything to that extent yet. I think we're still making our way through it, which is, I think he's taking the position that he's not willing to share anything Mr. Wade ever told him.
Yeah, that's what he's
period. Saying. Which that's a broader representation of attorney-client privilege than I've ever heard. And I think that's what we're trying to parse out. Is if the relationship starts, I've never heard anything that said everything before that point is privileged. Do you have something that I should know? Yes, sir. That's fine.
Before that relationship,
it may be more than that.
Being established, it was 2018 December.
He could be forced to answer. It all depends on if it's contempt. There's a lot.
After that, during which
obviously he doesn't want to answer the question because Wade is his friend. So he's doing everything now.
He has an opinion from the State Bar of Georgia.
Just so everybody understands, his attorney-client privilege, but he's not. The person on the stand is not saying attorney-client privilege. They're talking about confidentiality. So if I'm an attorney and you come to me to evaluate a case, and I don't take you on as a client, I still have the duty of confidentiality because you may go hire another attorney. So I can't go tell everybody your business.
6 months from now,
that's what the lawyer on the stand is saying.
it's not acceptable.
He's
It
saying I have a duty of
violates hundreds
confidentiality.
thousands of
It's not even
relationships in
privilege.
this state that we rely on in order for the justice system to function. This is an attorney-client privilege issue. We've done all the diligence we can as far as looking up the relevant laws, the relevant information. We do not have a waiver from the client. The client is present. Whatever.
There's no question. Why we're not barreling ahead is because I recognize the privilege. What we have to determine is actually what that privilege
Covered.
the scope of it, and when it started. And I don't think we've even gotten close to that yet.
I apologize, Judge. I thought December 2018, Mr. Bradley testified directly that is when the retainer and the divorce proceedings were beginning.
Yes,
The
that's what he did.
issues brought up by the state have to do potentially, if I've been.
So we have a starting point, but does that necessarily foreclose anything from that point onward?
Yeah.
If they started talking about something else
Football
entirely.
games. It doesn't. Yeah.
Divorce, of course not, Your Honor. But during the pendency, it would absolutely curtail that, especially as it has to do with observations, attendance at functions
Yes.
together, or other
Yes. But
realizations.
it all depends.
that Mr. Bradley
Can
came
he
into
legally
during the
answer the
pendency
question?
of
That's
the
what they're asking
representation.
now. Can this lawyer, remember, this is Wade's lawyer, can he legally answer the question?
We put Mr. Bradley.
Thank
in
you so
an
much. Thank you so much,
position
Captain.
because his
Thank you so much.
reputation means everything.
Okay, Mr. Sadon.
Your Honor, I think we're talking about two aspects of
This is Trump's lawyer, people.
arguably the attorney-client privilege. There's the attorney-client privilege, which is controlled by case law and statute,
Oh,
which
thank you.
deals with communications and furtherance.
Yes.
I don't hear that being the objection.
There was
objection
confidence.
is that there are confidential matters under 1.6, which in some form or fashion mean that once you start a relationship with attorney-client, that everything from that point on
It's confidential.
is confidential between
You see? Exactly
There's
what
no
I just
such
told
case
you.
law in Georgia
There's no,
that
which is
deals
no
with
such case law.
confidential
That's exactly what I just said. He said
Attorney-client,
confidence.
yes, confidential information, no. And I believe what's being argued by counsel, Mr. Bradley, is that he has received, of course, we don't have anything to write it, but he's received some oral advice that under 1.6,
Which is confidentiality.
confidential matters cannot be gone into, which is, according to them, everything that occurs between Mr. Bradley and Mr. Wade from 2018 forward.
Exactly what I just
There's
told
no
you.
such law
Confidentiality
that
versus
protects confidence.
privileged information.
Only communications.
Trump's
made
lawyer
in
got it.
And if I
So if it's
mistake, I
confidential, you can
apologize.
testify
I think
to
what
it.
we're
If it's
being told
privileged, you
is,
can't.
I don't have to say anything at all about Mr. Wade once I have an attorney-client relationship with him, because it would be deemed confidential, and if it's deemed confidential, I can't talk about it. And there's no such case law to that effect. in
That's
Georgia.
right.
There is no bar rule to that effect. The only thing the court has to do is say, are we talking about attorney-client privilege or pure confidences, or confidential information?
You might be listening to this
Once you
stream.
decide it's confidential information, you ordered Mr. Bradley to testify, and then it's up to his counsel.
He is listening to this stream because that's exactly what I just told you.
And Judge, that's an overstatement. We have not said that he can't testify to anything. The specific question on the table is, what observations do you have from Mr. Wade and Ms. Willis?
Thank you, thank you,
from
thank
that
you.
point on? Now, they, the defense and their teams, have made an allegation of some impropriety. That
Yes.
same impropriety could be related to a divorce proceeding on every level. We're not here to say we're not talking. We're here to say we're not talking about things that came into his knowledge associated with his representation during the divorce. I realize there's an evidentiary standard, and then I realize that there's the cornerstone of what we do, which is the bar rules.
So they are not arguing about the evidentiary standard now. You
Violate
state.
that, and the whole thing comes tumbling down.
They're arguing
I'm
about
saying
the.
you can't ask about, did Mr. Wade enjoy a beer at a ball game? That wasn't the question. The question was specifically relating to some impropriety that they were trying to dig into. That is privileged information.
And more importantly, Mr. Bradley has said twice now that he has no independent knowledge as it relates to what she's referencing. He has said it 2 times. So there's not a good faith basis for her to continue to probe into this
They are
area.
desperate to stop him from talking. Because he knows when this happened.
All right, Ms. Merchant, last word.
Yes, Judge. Judge, Mr. Bradley, if ordered, he's here by subpoena. If ordered to testify, it's not a issue with the bar. My question was not about attorney-client privilege. I'm being very careful not to ask anything that Mr. Wade asked in furtherance, but I've been informed that Robin Yerdy is on the Zoom. And so if we want to start back on our original plan, we can call Miss Yerdy and have her testify and then put Mr. Wade up and we can go through the privilege issue with him. And then we won't have to have all these objections, or else I'm happy to continue questioning.
So now the star witness is here. That's what we want to get
Ms. Merchant,
to.
you're saying that your understanding of the evidence that you plan to present, that these issues
they'll be resolved with this other
are
witness
affected by Ms. Yerdy in terms of.
So in other words, they're saying we have another witness who knows what's up.
I think,
right?
Thank you for letting me clarify that.
This is what
I
she's
think
saying.
that Ms. Yerdy is going to give me enough to get Mr. Wade on the stand.
In other words, so she says, I have another witness that can establish the relationship prior to him working at Day's office. So I can use her to get him on the stand, and then we don't need this guy with the privilege issue.
And then I may not even have to Bradley at that point.
In other words, Bradley, you don't need Bradley because the other witness can testify to the relationship instead.
Judge,
we're going around it.
Sorry, who's?
I'm on Zoom, Your Honor. Attorney Durante Partridge, Judge, on behalf of Ms. Yerdy. Your Honor, when we were here for the motion to quash earlier this week, it's my understanding, as represented by defense counsel, that Mr. Bradley's testimony is, so to speak, the bridge that was built to involve my client, Ms. Yerdy, into this matter altogether. Now it seems as though that is being usurped, and now she is being the quote unquote foundation for defense counsel's presentation this morning. So we do object to that, Judge, and would renew our motion to quash the subpoena because this is completely contradictory to what we had via the hearing earlier this week, Your Honor.
Judge, may I respond?
Okay, Ms. Merchant. Mr. Partridge, as I recall, that did not apply to your client as much. The original motion to quash that you filed said she had absolutely no knowledge about anything. What Ms. Merchant proffered and what I didn't hear you saying was not the case is that at some point Ms. Yerdy lived in a residence and shared a residence with Ms. Willis and potentially Mr. Wade at some point. So I think she's directly involved in the center of this. I don't think that really needs much in the way of foundation.
Yeah.
And Judge, I apologize, Your Honor, to talk over the court. That information, however, Your Honor, is my understanding came from Mr. Bradley, and that information was incorrect, as I informed the court earlier this week as well. There was never any time that Ms. Yerdy and Ms. Willis lived together. There was a sublet of a condo that Ms. Willis resided in that had absolutely nothing to do with that of Ms. Yerdy outside of Ms. Yerdy subletting it to Ms. Willis. Ms. Yerdy actually moved into a different residence per our conversation with Ms. Merchant yesterday. That is exactly what it is. So there was no overlapping or any time that they stayed together, nor does Ms. Yerdy have any information as it relates to Mr.
doesn't want to testify. She doesn't want to testify nothing.
Condo as well with that of Ms. Willis. So again, Judge, I'm renewing.
No, we don't need to hear it again. Ms. Merchant.
Judge, luckily I don't have to tell the state or them everything that I plan on introducing a witness for in response to their motion to quash. She has a lot of personal knowledge. And when we had a motion to quash, I had to get over a good faith basis, and I presented that to the court. I did not spend 4 hours going through everything that this woman's going to testify to. She has personal knowledge.
Is she actually here?
I think she's on Zoom. What I understand, Mr. Partridge.
Mr. Partridge, is your client with us?
She's on the Zoom platform, Your Honor, since I'm in Richmond County via my conflict, but she is on the Zoom platform at this time, Your Honor, in the waiting room. I believe she may have been admitted. I see a Robin on my screen. I'm assuming that is my client.
Ms. Merchant, you want to examine her by Zoom?
That's fine.
This is going to be good. All right.
We will waive
Mr.
any
Abadi.
Sixth Amendment objections to it. That's fine.
My only objection was the representation at Monday's hearing was the good faith basis was based on what she learned from Terrence Bradley. And we know that is false. It's not true.
They fighting
no good faith basis.
to the nail.
Renew our objection and to quash it.
I am having too much fun.
That was not in regards to Ms. Yerdy.
It certainly was. It was like the 20-minute mark in the hearing.
Judge, she has personal knowledge of this relationship.
She does have
represented on Monday. Personal knowledge came from Mr. Bradley. She has no good faith basis to explore this fishing expedition as it relates to Ms. Yerdy. This is a blatant misuse of the process.
Ms. Merchant, I do believe that when we went through the motion to quash, there were you grouped them into two categories, and each one of them we said that they were going to be impeached by Mr. Bradley.
We took Ms. Yurdy outside of Fulton County, Judge. So we talked about Fulton County differently than Ms. Yurdy. We took Ms. Yurdy out separately. She was different than Fulton County because there wasn't other issues. And again, so we're arguing a motion to quash. I responded to their argument on the motion to quash. Did I tell them that she's going to testify that she's known Miss Willis for years and that her middle name is Latrice? No, I didn't tell them everything she's going to testify to. I don't, like, if you wanted me to, I could have, but that has nothing to do. There's a witness that contradicts what they have said in court, and they're doing everything they can to keep her off the stand and keep the truth away from this court. They filed a motion to quash. I showed a good faith basis. If my good faith basis is Mr. Bradley or Miss Yurdy or texts I've seen, it's still a good faith basis.
That's true.
There's no law that says I have to tell them every single good faith basis I have ahead of time. If we did, we would never have trials.
All right, Ms. Merchant.
She's right.
Appreciate the argument of counsel. I think the standard on a motion to quash and a subpoena is not one where we're required to completely flush out and litigate every reason the witness may be relevant.
She's right.
So we'll take these one at a time with Ms. Yurdy.
Here we go.
To quash.
Finally, we get to the witness.
Your election and to proceed in your presentation of the evidence is to call her, then that's what we'll do.
Thank you, Judge.
Finally.
So, Mr. Bradley, you may be excused for now. Thank you, but subject to recall. We will call Ms. Yurdy.
They don't want this. They like, don't put her on the stand, damn it. Don't put her on the stand. She's coming up. Oh, this is so crazy. This is like, what's going on here? Oh my God. So here we go. The Zoom call. This is the Zoom call from hell. Now remember, all of this is for one question. So all we're trying to find out one question. When the hell did this relationship start?
There we go.
What they said in court
Scott, if you could swear in the witness.
True, or what they said it was a lie?
Yes, I
We're
can.
trying to flush out. When the hell did this relationship start? Here we go.
Testimony to get a court will be the truth. Would the truth will help you?
Yes,
Would you please state and spell your full name for the court?
Robin Latrice Yurdy.
Okay, here we go.
Thank you, Ms. Yurdy. Thank you for being here. Can you tell the judge when you first met Miss Willis?
Land Foundation. How do you know what you know?
Willis. In college.
Okay.
So 19.
She's good. She's good. She's worth her money.
Probably 90 or 91.
Okay. And have you been friends since 1990 or 91?
Yes.
Okay.
Miss Willis.
When was the last time you spoke with Miss Willis?
March of 2022.
Okay.
Remember, she's
from 1991-ish till 2022. Were you what you would consider good friends with Miss Willis?
Yes.
Okay. And did you all share personal information regularly?
Yes.
Here we go.
And did you even come and work with her at the DA's office?
Yes.
Well, that foundation.
And when she needed a place to stay, did you let her stay at your apartment?
Yes.
It was a condo, right?
Condo, yes.
There it is.
Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great.
Well, that foundation.
And you know that Miss Willis and Miss Wade met at a conference in October of 2019?
I'm going to object to that, Your Honor, without a foundation for how this witness would know that. If Ms. Merchant can establish she has personal information of that, then certainly that's
Look,
something the
she's a
witness can testify
friend.
to.
She just laid out all that information.
Understood, Ms. Cross. All right, Ms. Merchant, if you could lay the foundation.
Do you have information that Miss Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not sourced to personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again. Personal knowledge.
Overruled.
Yeah. Now you're being stupid.
Thank you.
I mean, just personal knowledge. It's just, when do you have any knowledge?
Do you have personal knowledge of when Willis and Wade met?
Yes.
She told me that they met at a conference. I don't know what conference.
Okay.
I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this.
What do you mean?
It's hearsay that was.
But she said she told me.
She told me.
Yes, it's statement against interest, Judge.
Yeah.
If Ms. Willis,
Just pause.
I'm sorry.
Okay, Mr.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms.
She told me.
Willis, District Attorney Willis, had a conversation with her.
Yes.
There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witnesses testified to came from Ms. Willis, and
It
there's
is an out-of-court statement.
we have a
The
hearsay.
truth of the matter is stated.
Why wouldn't she be considered a
But why
party
wouldn't she be-
opponent? in
Yeah, because
context?
this would be disqualifying her.
A representative of the state, Your Honor. This isn't private litigation or civil litigation. Obviously, the court's aware this is, Ms. Willis is not on trial. Ms. Willis is not a party to
This
the
is disqualification for
litigation
her.
outside their obligation to pursue criminal charges for the state.
Ms. Merchant, I guess it's evolved into a hearsay objection.
Yes, Judge. And we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. If there is a hearsay objection as far as that issue. But we do still think that it's a statement against interest. Ms. Willis has filed a
party
document
opponent in this case.
that
This is the
states that
disqualification
they
of her.
met at this
How could
municipal
she
court
not
conference.
be-
So
how could this not be hearsay?
Your Honor, I think maybe I can streamline.
And
a little
she's
bit. The state will
also
stipulate
said
that
they
District Attorney
made it
Willis
then.
and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. There's no reason to get it secondhand from this witness. Well, that's true.
This is
All right, you accept the stipulation, Ms. Merchant?
yes. Am I permitted then to ask questions about that since it's now not hearsay?
If it's just to a stipulation, if it's just to that basic fact, I don't think we need a question, but if there's a follow-up that you think is admissible, go for it.
All right.
Ms. Yeardy,
My God.
you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. No
It is
foundation
leading.
has been laid for how this witness would have personal knowledge of that. And until that's happened, the state objects.
Okay.
Judge,
I think you can do a yes or no and then follow up with how she knows it.
Yeah.
thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
When was it?
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke,
All right, here
you
we
said
go.
it was shortly after the municipal court conference, though, correct?
Yes.
Okay.
Shortly
So
after. There we
you
go.
know that their relationship, their
Finally.
personal relationship began shortly after this municipal court conference.
Yes.
And when I say
Uh.
personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
That's it.
And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
Which she essentially now has testified to is that the
And you
affidavit
were
that Wade
essentially her
filed
best friend during this time, right?
is full of lies.
Not best friend. Good friend.
Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
Yes, the ball game.
And so from
game.
everything that you saw,
Tough to get it out.
heard,
The ball
witnessed,
game.
it's your understanding that they were in a romantic relationship beginning in 2019?
Because he said, remember,
Yes.
that means his affidavit is a
And,
lie. If what she's saying is accurate.
When you left the DA, oh, I'm sorry, let me ask you. You said that Ms. Willis came to live with you in April of 2021. I'm sorry, April 1st, 2020 or 2021?
She didn't live. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
Okay, I had it both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo?
Yes.
And is it your understanding that that's because she needed to have her own space
Yes.
away from her father?
Yes.
Okay.
This is monstrous.
When you
Oof.
left the
What's
DA's
Wade
office, was it, were you fired?
No, I resigned.
You resigned, okay.
Yeah, she's scared.
Just one moment.
She's intimidated. So just so we know what's going on here, Wade has said the relationship didn't start till after they were hired. Right now we have Willis's friend who rented her the apartment who's saying that's a lie.
Can you tell us why you resigned the DA's office?
Hired at the DA's office. That's what this is saying. They have both.
The number of things that was happening.
She is saying they have both lied about when
A number of things that were happening. Is that what you said, ma'am?
under oath and in court documents. That's
Okay.
what this woman is saying.
What was happening that caused you to resign?
Thank you for the
It was a spiral of things. So, I guess the last straw is I was put in a department that I knew had no knowledge about. Something happened, and I didn't like it. They didn't like it, and that was it.
Okay. Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that. Okay. And so without going into all the painstaking details, there is no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
What's the question?
She says
you have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
Ooh.
And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
Okay.
Personal observations.
No other
I know for
questions. Thank you. The other folks may have some questions for you, Ms. Yurdi.
Sit down.
This is crazy.
If it's
Here we
more
go.
than a couple questions, then sure. But if not,
It's only a couple questions.
okay.
I think, co-reporter, hear me okay?
You got to ask us something. This is
Let
damning
me be
to the
very
case.
specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
I'm saying right now with the tell me.
Thank you for becoming a member.
Yes.
Did she tell you that in the year of 2020?
Can you say stick me
Yes.
over?
In the year of 2021?
Oh
Yes.
my God.
Are you certain that Miss Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2020?
Remember, both of them said it happened after.
Yes.
Now,
He got
did you
the job.
also have observations
He got the job in
of
2020.
Mr. Wade and Miss Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are common among people having a romantic relationship?
Yes.
You see the
Such
questions
as,
now?
can you give us an example?
The questions now all about the relationship. Before
Hugging, kissing,
hugging,
kiss
kissing.
affection.
All before November 1st of 2021.
November
correct?
1st, 2021
Yes.
is
That's all I
when
have.
Stocks.
Wade said that he had never had any extramarital relationships. She's saying
You
it.
say that there was a period of time when you and Miss Willis lived together?
No.
She's just essentially said that
Mr. Durham.
Wade and Willis have committed
Nothing
perjury.
for me, Your Honor.
Mr. McDougall,
Nothing, Your Honor.
Mr. Rice.
That's what this woman is saying. She's personally observed the relationship,
you-
and Wade
were
and
you
Willis
aware
have
in
committed perjury.
2021 of any
That's what we're
trips,
listening to now.
Social trips that Miss
Shit.
Willis and Mr. Wade took together?
No.
Are you aware of any social trips that Miss Willis and Mr. Wade took together in 2022?
No.
And are you aware of them in 2020 or 2021 spending the evening together overnight?
No.
No further questions.
Mr. Gillen,
No question.
Mr. McCullough, and Mr. Cromwell.
No questions, Your Honor.
Ms. Cross.
I do have some questions. Thank you, Your Honor. Ms. Yurdi, we haven't met before, is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, and we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes.
Who paid the rent?
She didn't.
Nathan Wade ever pay the rent?
No, dipping your pen.
No.
Yeah, this is tough. Yeah. Thanks for that super chat.
And you
Brett,
never told
but
anyone
right.
otherwise?
It looks like he's going down.
I didn't hear your answer there, Ms. Yurdi. Did you ever tell anyone otherwise?
No.
All right. So let's talk for a second about your time at the District Attorney's office. You were disciplined several times in the District Attorney's office during your employment there, correct?
They're going to just try to destroy her credibility
No.
now. You were a bad
written up ever for poor
discipline.
performance, Ms. Yurdi.
Once, not several.
One time you were written up for poor performance where you counseled several times about your performance in the District Attorney's office that was subpar.
Now they're trying to destroy her
No.
credibility.
Did the District Attorney tell you that your performance was insufficient and that you were going to be fired?
No.
They're trying to make
That
her
never
to,
happened.
to an angry ex-employee.
No. Maybe when we went at the end. What's the question?
Question, Ms. Yurdi, was did the District Attorney ever counsel you on your poor performance in the District Attorney's office prior and inform you that you were going to be fired?
Just so you guys know, this is were you a bad employee and is this just revenge for being fired?
I don't really know how to answer that.
That's where they're getting to.
I'm looking for the truth.
I don't really know how to answer that. I mean, a situation happened that wasn't my fault, and I either was going to resign or be let go. So
You understood that that was the situation. You could resign or you could be let go.
correct. Yes.
You were not welcome to stay.
No.
So is she lying now about when they started the relationship? Is she lying about when she rented the apartment? Is she, that's what she's
And the
trying to
conversation
say.
where you
Motive
were
to
informed
lie.
that you could resign or you could be fired, that conversation was not the first conversation you had with the District Attorney about your poor performance in the office, correct?
Well, it was kind of a spiral, but no.
Yeah, it was. Whatever the situation was.
Excuse me.
Commentary by counsel. Questions are fine.
Understood, Mr. Staino. Ms. Cross.
Ms. Yurdi, the circumstances of your leaving the District Attorney's office ended your friendship with the District Attorney Willis, correct?
Yes.
Y'all haven't spoken since.
No.
All right, I want to talk about the representations that you made here this morning, Ms. Yurdi, about any relationship between District Attorney Willis and Mr. Wade.
The reason why she's going through
I want
this
you
is
to
the
tell
ball
me
game.
what was the first time let me ask it this way. You
This
said
is the
that
ball
District
game for
Attorney
Fani
Willis
Willis.
personally informed you of a romantic relationship. Is that what you testified to?
Yes.
When did that conversation that you purport to have, to recall, when did that happen?
I mean, I don't have a month or a day,
Where were
but just talking in general.
Yeah, you're talking to a friend. You don't know exactly, the exact date and time.
Your Honor, you'd like to keep this witness under,
we gotta destroy
All right, thank you,
this
Ms. Cross.
witness.
Redirect, I'm sorry.
All right, on those points only.
Redirect.
Yes, just those points. The state asked you a lot about when you were let go, when you resigned. did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county for Ms. Willis that caused you to not be comfortable working there anymore?
No,
And I didn't tell you how to testify here today, though, right?
right,
And everything you've testified to is from your personal knowledge?
yes,
Okay. And you've told the truth here today?
yes.
Okay. Judge, I believe she's only under my subpoena, and I'm fine releasing her from that subpoena. Oh, I'm sorry.
By show of hands from other counsel, starting with Mr. Sadow.
Anybody wants to question her?
Your Honor, I believe the door's been opened now to ask this particular witness about statements Ms. Willis made to her. She brought it up on cross-examination on a couple of occasions.
She did open the
Ms. Willis
door.
say this or inform you of that.
Yes.
So I'd like to now ask her questions directly about what Ms.
Well, told her. That's true. There was hearsay before. She's
I
opened
think we'll take those one at a time, question by
That's
question,
true.
and we can address those to
Trump's
see. I
attorney's
don't know about
good.
a complete opening of the door. We'll see where we go.
She opened it a little
First
bit.
time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence, what she
Thank you
said.
so much.
No,
Do you remember the first time she told you, in whatever words were used, that there was a romantic relationship?
no,
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Ms. Willis and Mr. Wade?
what's the question?
Yeah, I'll ask
That's
you again.
true.
Is the nature of your then relationship with Ms. Willis such that you were having these ongoing conversations, that is, best friend type conversations about her relationship with Mr. Wade?
I don't remember.
Without getting any further in too much detail,
Thank you,
is there
Mr.
any
Thank you so
doubt
much.
at all that Mr. Wade and Ms. Willis had a romantic relationship as was told to you
This is the door closer.
prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no, no doubt.
No
All
doubt.
right.
That's
Any other
the door
defense counsel by
closer.
show of hands? Seeing none. Last recross
They
from
both said it
Ms.
happened after
Cross.
that
Anything
point.
else?
Not this time, Your
He
Honor.
said
We've
there's
asked
no
the
doubt it
witness
happened
remain under
before.
subpoena and subject to recall.
Judge, she's under my subpoena, and I'm releasing her from my subpoena. So they want to subpoena her. They're welcome to do that.
Ms. Cross?
I would prefer that the court keep her under subpoena. I
Sure.
think, given the representation of Ms. Merchant, given how she intends to
Oh,
proceed today,
in
that
the
this
crowd,
witness
yeah.
may need to be recalled.
All right,
Dang.
understood.
Dang,
In
dang.
the interest and knowing that we may have to bring witnesses back and forth, I think
That's a hell
it's
of
in the
a.
interest of effective presentation of the evidence here.
That's
Ms.
a hell of a
Yurdy, you
warning
are
right
still going to
there.
remain under the auspices of your subpoena.
Wow.
And so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today or tomorrow. Understood?
This may go
Okay.
over 2
All right.
days.
Don't discuss your testimony with any other potential witnesses. All right.
All right.
All right. You can log off.
Shoot.
And Judge, I'd ask, just can Mr. Partridge stay on for just 1 moment?
For what reason?
The state have made some allegations that I misrepresented some things to the court, and I'd just like the opportunity to clear that up, that Mr. Partridge is the one that told me that they lived together for a month. They've called me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Ms. Merchant, I think you've made your position clear. That's
Yeah, it's
I don't think we want me to get sidetracked on
Yeah.
that.
Come on. Yeah.
All right,
I'm not gonna trouble.
Ms. Merchant, you can call your next witness.
You got
Judge, may I be excused as well, please?
All right, take care, Mr.
something where
Partridge.
you got to know
Yes.
you've won. She
All right.
won this argument, right?
Ms. Cross.
She
Your Honor,
could have told me a lot. You've won.
Motion to quash
Take the
Mr.
one.
Wade's
Move on.
subpoenas was held in advance, waiting for the representation. I believe that the good faith basis that Ms. Merchant represented on Monday, I think that's clearly not accurate.
What?
Understand the testimony that's now in the record. Mr. Wade is
That's it. It's done.
available, but we maintain that at this time, that the motion to quash probably should be granted, but understand the court's ruling.
It's garbage.
Well, Ms. Cross, I'll say yes. On Monday, it did seem like the focus was that Mr. Bradley would be the hook that makes every witness potentially relevant. And we really haven't been able to explore that on the privilege issues that we'll likely have to tackle again later. But for now, as it
Come on, there's more than enough.
The evidence in front of the court at the moment is that we have a witness who has said this relationship may have predated the affidavit that Mr. Wade filed. I don't see a way around
How do you get around that?
the relevance of his testimony.
Yeah.
And so I'll deny the state's motion to quash subpoena Mr. Wade.
How do you get around that?
Ms. Merchant.
That's the ball game, people. He's got to testify. You see, he's gone. He's outside the room. That's it. It's the ball game. You got a witness who said, I saw them. They had a relationship. I had personal knowledge. I was her best friend. What more do you need? I understand this. This isn't good for Fani, but that gives you that gives them everything. Now you continue to roll it up. Wow. Fani's team, I object. It's devastating my case. Hell yeah, it's devastating to the case. Remember, people, remember. All of this came down to one thing. When they, in November 2021, both Fani Willis and Nathan Wade said the relationship started after that point. Now you have a live witness who says, no, that's a lie. I know because I was there. The relationship started before that. Now he's on the stand testifying under oath. What's he going to say? Did it happen before or did it happen after? If it happened before,
Nathan Wade,
he just lied in his affidavit.
N-A-T-H-A-N-W-A-D-E.
Good morning, Mr. Wade.
Good morning.
Prior to filing this motion to disqualify, you and I were friends, correct?
Yes,
And in fact, I supported you when you ran for judge in 2016.
you did.
I wore your shirts. My kids wore your shirts.
Ms. Merchant,
Signs.
your personal opinions have no relevance.
Get that out of here.
I mean that in the best way.
That's
all right?
completely fine. I
Just
will
like-
respond. Thank you. No.
It's like, come on, we know what
Thank
we're
you.
here for. All this bullshit.
You filed for divorce from your wife on November 2nd, 2021.
Yes, ma'am.
And in that divorce proceeding, did you file answers, things such as interrogatories?
I did.
Okay. And so interrogatories are where you're responding to things that basically answers that the other side is asking.
Yes, ma'am.
And I've got your complaint for divorce. I'm just going to mark it for the record as Defendant's Exhibit 2. The first interrogatories that you answered, those were December 27th, 2021. Is that right?
Thereabout. Yes, ma'am.
Okay. And in those,
Right. I know what
you
you're
were
talking
asked different things, but those are sworn. You actually swear to those. You verify them, right?
Yes, ma'am.
Okay. And so that verification is where you're swearing under oath that everything in it is true.
Yes, ma'am.
And let's see,
Yeah, that's what the judge said. Yeah.
you were asked if you had any documents which relate to the purchase of gifts by you to any person other than the defendant with whom you have or had a relationship, romantic relationship from the date of your marriage, correct?
Yes, ma'am.
Okay. And you responded under oath that you didn't have any documents to that.
That's correct.
You again responded to an interrogatory. You updated those responses on May 30th, 2023.
Yes, ma'am.
Wow, thank you so much.
And you actually sent those directly to opposing counsel in the divorce?
Yes, ma'am. I think so.
But in that one, you answered none again to that question, correct?
Yes, ma'am.
So May 30th, 2023, you said that you didn't have any documents showing any purchase of anything with someone that you had a romantic relationship with.
I believe the interrogatory was gifts.
Okay.
Not anything. Yes.
And I have it if you want to take a look.
So something was given, but
I'm
it
gonna
wasn't
mark,
a gift.
okay, so just for the record, I've got your complaint for divorce marked as number 2. I've got the verification and the interrogatories from 2021. I'm gonna mark those as 3. And then your May 30th, 2023, I'm gonna mark as 4. Judge, may I approach the witness?
You may.
Now we're getting comfortable. Well, I just said gifts, not anything. Because he knows she got the receipts to show that he purchased stuff for Fani, so that's why he's got to be careful.
Thank you, Judge.
That is dumb.
All right, if you take a look at what I marked as 2, 3, and 4. Just see if you recognize those.
I do.
And are those, that's your divorce complaint, and then your 2021 interrogatory and your 2023 interrogatory, correct?
Yes, ma'am.
Okay, are they a fair and accurate representation of what is filed in that case?
Yes, ma'am.
I'd move to admit those into evidence.
And this is 2, 3, and 4?
It's 2, 3, and 4, yes.
All right, any objection from the state?
The divorce. It's on the district.
No objection to 3 and 4, and subject to Ms. Merchant's representation that 2 is a filing of divorce. I just don't, the divorce complaint, I don't have that in front of me, but subject to that.
How do you get out of this view, Fani?
All right, and by show of hands, any objection from other defense counsel?
She's building up to. She's building up to the.
Then it's 2, 3, and 4.
The coup de grace, right?
This should be.
When did the relationship start? That it started with God.
Admitted without
Is
objection.
that true? What's he going to say?
So that interrogatory that you filed in 2023, that's one where you said no, that you didn't have any documents relating to the purchase of gifts, that you had a romantic relationship with someone, right?
Which interrogatory are we talking
Number
about?
4, 2023.
Which number in the interrogatory?
Number 4.
So which number interrogatory are you referring to?
It's defendant's exhibit number 4.
I have defendant's exhibit 4 here.
Uh-huh.
Which number interrogatory are we referring to?
Oh, which number out of the questions?
Yes, ma'am.
It is number 20, 24, 25, 26. All of them.
I like how people are like, Nate's a liar, Nate's a liar. I'm like, what the hell am I lying about? I'm just saying. I'm like, oh yeah, I forgot his name is Nate too. I'm like, damn, I'm just watching this shit. I'm like, I'm the liar. Just so everybody understands what's going on. Nathan Wade has said the relationship started after he was working. Fani Willis said after he started working with Fani, that's when the relationship started. They now have found a witness, Fani Willis's good friend.
I guess they're all numbered 1.
That said the relationship started not only before he started working here, before he got a divorce.
And then the
so he's now being confronted with sworn statements he's made under oath that said that the relationship started after he. So that's what they're giving him now. Here are your sworn statements.
I don't know how to tell you what number 1, because when you responded, you put number 1 on all of them.
You just point to it.
This one. This one, I'm talking about this number 1, where it's tabbed. There's 2 number 1s that are tabbed.
Okay.
And there's no page number, but it is the second page.
All right.
They're asking if you have any receipts for restaurants, hotels, bars, things like that.
The first number 1?
I believe it's the second number 1.
The second number 1?
Act confused.
Okay.
So it asks you if you have any receipts for things like restaurants, bars, hotels, things like that.
Now you know she has the receipt.
Where you accompanied a member of the other sex romantic partner. Correct?
Now you know she has these receipts. That's why it's taking them a long time to
answer. It says identify any and all occasions.
Mm-hmm.
Okay. And so it says to identify any and all occasions where you entertained a member of the other sex, okay, who's not related to blood, and including dining, drinking, restaurants, bars, pubs, hotels, all of that. Okay. And what was your answer to that?
No. The answer was no. She has the receipts to say yes. You know his answer is no.
None.
None. Okay. So May 30th, 2023. You prepared this document,
I did.
submitted it,
I did.
and it says none as far as entertaining a member of the opposite sex.
It does.
Okay, no hotels, no bars, no restaurants.
Correct.
Okay. You again updated that. Let's see, you updated it on December 22nd, 2023. And I'm gonna mark that as defendant's number 5, and I have copies.
Now we have it updated.
Is that correct?
Yes, ma'am.
The updated.
And then you updated it once again on January 26th, 2024, correct?
Yes, ma'am.
Okay, that one. May I approach the witness again, Judge?
Is that what you're marking as Defense Exhibit 6?
Yes, Judge, I'm marking number 6 is the January 26th, 2024 interrogatory, and then that one. And then number 5 is the December 22nd, 2023 interrogatory response.
All right, are you tendering those at this time?
Yes, I know.
All right. Any objection from any counsel to Defense Exhibit 5 and 6?
Yes, Judge. No objection.
Thank you, Ms. Cross. Seeing none others.
Luckily, I have for you. So now that you have those, let's just talk about those for a minute. Those were verified, so sworn under oath.
Mm-hmm.
Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right?
Mm-hmm.
Okay. In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
And you were actually held in willful contempt.
Yeah, I'm going to object to the relevance of
Ms. Merchant.
His credibility is relevant, Judge,
Yeah,
and if he was held in
credibility
willful
is
contempt
relevant.
for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or crime of conviction or anything else allowed for impeachment under the rules of evidence?
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine. If he's made misrepresentations in these pleadings, you're here to determine whether or not he's telling the truth or not. So if another court has held him in contempt and that's part of the divorce proceeding, I think it's relevant.
But just contempt generally can be for many different things. Like a failure to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
He may not have to. Ms. Cross.
I object to the relevance of that. That's clearly not a proper impeachment. We're going pretty far afield into divorce matters that don't have any direct relevance to anything that's pending before the court. I object to the relevance of that and further.
All right, I'm not seeing that being a proper grounds for impeachment. It's sustained.
Okay,
Yeah,
let's
that
talk
makes
about
sense.
this December 22nd,
I still think it
2023
goes to his credibility.
verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that's an accurate read of the interrogatory.
All right, let's be precise, Ms. Merchant.
And you, please read it. I want to make sure I'm accurate. Please read it.
Which number?
This one actually has a number. I tabbed it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control or any other person or entity which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
Okay. And you answered that you did not have any documents to that effect, correct?
Correct.
And
Now looking
that
at
was
that.
on December 22nd, 2023.
Yes, ma'am.
You updated those responses again after the motion to disqualify was filed, though, correct?
When was the motion filed?
January 8th,
so much. Thank you so
2024,
much.
when I filed the motion to disqualify
Thank you
you and
so much.
alleged that
Thank
you
you.
had a romantic relationship with Miss Willis.
Yes, ma'am.
After that, you updated these responses, correct?
Yes, ma'am.
And so your new responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24-5-505, correct?
Yes, ma'am.
And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that. And then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Okay.
Wow.
And just to be clear, was it?
Sorry, I'm going to object the characterization of Fifth Amendment privilege. I think it was a statutory privilege, and that's quite different.
That's what I was just about to ask him. So that privilege covers infamy or Fifth Amendment privilege, correct?
So it was a privacy privilege is what I updated my response to do. Once you filed your motion to intervene in my divorce action, I then figured that you were in talks with my former wife's divorce lawyer.
Okay.
And because of that, I asserted a privacy privilege because I didn't want the proceedings of my divorce to bleed over into the proceedings in this case, which is the case that obviously you're involved in.
So your answers in December of 2023 that you didn't have any documents about any travel that you took with Miss Willis, that wasn't true though, correct?
They didn't ask me about any documents regarding Miss Willis.
Getting tough.
A romantic partner. They asked you for documents regarding a romantic partner. So I'm sorry, I inserted Miss Willis's name. Let me rephrase the question. They asked you for documents about travel with a romantic partner in December 2023. And you under oath said you did not have any of those, correct?
I did not.
Okay.
And they asked me about gifts.
Right.
I never purchased a gift for Miss Willis.
And they asked you about receipts for dinner, receipts for drinks, hotels, bars, and restaurants. And you said you did not have any of those.
I did not and do not have any receipts for any of those things.
Okay. And part of the civil discovery, they say that even if you don't have it in your pocket, if it's within your purview, you got to get it and give it to them, correct?
Your Honor, I'm going to object again to the relevance of the questions about the scope of civil discovery. I think she's asked him about statements he made in pleadings. The answers are already in the record. And
all right, to the extent you're trying to establish a prior mistruth, Ms. Merchant, I'll allow you to ask a few more follow-ups, but if it's not there, we have to move on.
Thank you. So in 2023, December, you said you didn't have any receipts.
I do not have any receipts. I did not have any receipts.
But you did travel with Miss Willis in 2023, correct?
I did.
And you traveled with her in 2022, correct?
I did.
And you traveled with her in 2021, correct?
No.
So you only traveled with her in 2022 and 2023?
2022 and 2023 is what I recall.
That's what you recall?
Yes.
Okay. So you just don't remember if you traveled with her in 2021?
2022 and 2023 is what I recall.
Is what you recall. My question is, did you travel with her in 2021?
Not recalling any travel in 2021.
So it's not yes or no, you just don't remember?
I'm not recalling any travel in 2021.
So you did not travel with her in 2021?
Your Honor.
No, this has been covered. Let's keep going.
Thank you. Let's see, you filed an affidavit in this case, correct?
I did.
Okay, and I marked that already. I gave it to the state as number 1. So that's exhibit number 1. May I approach, Judge?
Right.
Thank you. In that affidavit, you swore under oath, correct?
Yes, ma'am.
And in that affidavit, you swore that, well, first of all, do you recognize the affidavit?
I do.
Okay. Did you sign the affidavit under oath?
I did.
And you gave this affidavit specifically to refute the allegations that I had raised?
Yes, ma'am.
Nobody forced you to sign this?
No, ma'am.
You chose to sign it?
I did.
And you signed it on purpose to admit into court to refute allegations?
I did.
You signed it specifically to prove that you were not in a relationship with Willis prior to November 2021, correct?
Correct.
Okay. And you were a lawyer when you signed it?
I was.
And you're still a lawyer today, correct?
I am.
When were you barred?
1999.
Okay. And you believe that your relationship with Miss Willis is subject to attorney-client privilege, correct?
I'm going to object to that, Your Honor. I don't think that's factually correct.
This is interesting. This is getting interesting.
I don't think it's appropriate to question this witness about the scope of his attorney-client privilege. He's got an attorney who can speak for him for that, but questioning the witness, I think, is inappropriate.
All right, so a lot to unpack there. The question simply that, does he believe there's a relationship that exists in the terms of attorney-client privilege between him and Ms. Willis? Is that accurate,
Yes,
Ms.
Judge,
Merchant?
it was. I asked if he believed his relationship with Ms. Willis is subject to attorney-client privilege.
Okay, I don't see why yes or no would be barred.
Maybe I'm not understanding the question. If the question is, does
They are fighting everything.
Willis have an attorney-client relationship?
It is not.
There's no foundation for that. If the question to the witness is, does his relationship with District Attorney Willis impact his attorney-client relationship with his divorce attorneys? That I don't think is an appropriate question for that witness. First, first I believe is a proper phrasing. The second, I think there's been a representation that Mr. Wade preserves and doesn't waive anything, and so I think asking him particular questions in order to potentially backdoor a waiver is inappropriate, and that's my question.
This is getting in.
Trying to again assess where a privilege does or does not exist, and we're not actually getting into it. I think that
doesn't make
we
any
can
sense.
establish those, parameters. But Ms. Merchant, can you rephrase the question based on that concern, and we'll see where we are.
Yes. Do you believe
You guys see now how
that
lawyers
your
make it so
relationship with Ms.
complicated?
Willis is subject to an attorney-client privilege? Not if you and Ms. Willis have one, but do you believe that that relationship is subject to one?
I'm going to object to that question as it's phrased. In what context? Any conversation with his attorneys is privileged. That I think is clear. What's not clear to me from that question is Ms. Merchant asking in the context of your communication with your attorneys, is that, or outside that context, is it?
Right. And Ms. Merchant, I think we need to figure out what are we getting at with this?
I'm just trying to figure out if he thought that their relationship is subject to an attorney-client privilege. I mean, it's been asserted. I think it's going to be asserted, and that was all I was asking.
I mean, the actions themselves wouldn't be at issue. It's more
If
communications.
someone saw them, someone had knowledge of it, is that attorney-client privilege? I want to
All right. Well, I guess I would find his legal opinion on this isn't relevant. We can deal with that as it comes up. So sustained.
Yeah.
In 2022, in this affidavit, you swore that you and Willis developed a personal relationship.
Yes, ma'am.
And you said that didn't develop until 2022, correct?
That's correct.
And that's different from what you said in your pleading in May 2023 in the divorce case, correct?
No, ma'am.
In May 2023, when you were asked if you had if you'd had any affairs, essentially, and you said none.
That's correct.
Okay. So in May, you said you had not, in May 2023 in the divorce case, you said you had not had a personal relationship, an affair, a romantic relationship with anyone.
That's correct.
But you told this court in the affidavit that you did have one that started in 2022. So that would have been ongoing at 2023.
So here I think there's a distinction, if you'd allow me to explain. The interrogatory asked the question during the course of your marriage.
Or to date. It actually says, I'm going to request that the witness be permitted.
Mr. Wade.
So my marriage was irretrievably broken in 2015, ma'am, by agreement. My wife and I agreed that once she had the affair in 2015, that we'd get a divorce. We didn't get a divorce immediately because my children were still in school and I refused to allow them to grow up without their father at the time. So we waited. We waited until the youngest graduated and we dropped her off at college and then filed for the divorce. So if you're asking me about the interrogatory as it relates to having the 2022 relationship with District Attorney Willis, I want to say because my marriage was irretrievably broken, I was free to have a relationship.
So the question though,
he was
if you
divorced,
had a
but he was.
relationship. And in 2023, you said you did not. And that is different than what you said in this affidavit, correct?
No, ma'am. I said during the course of my marriage. So in
So you believed it
2015
too.
Let him finish, Ms. Merchant.
So in 2015, my marriage was irretrievably broken. So I did not have a relationship with anyone during the course of my marriage.
And in that interrogatory, they asked you if you had any receipts for travel with someone of the other sex up until the time you were answering.
So even though he was legally married, he really wasn't married.
Yes, ma'am.
So when he
And you said that you didn't.
He's really
You've
parsing
already
words here.
testified to that earlier. But in this affidavit, you swore that you had travel expenses and shared expenses on travel with Ms. Willis.
Again, during the course of my marriage, I had no relationship or receipts.
I'm not asking about during the course of your marriage.
Your Honor, I'm going to ask the witness to be allowed to answer the question.
Continue. I have no problem with him answering.
Okay. As it relates to receipts today, I don't have any receipts, man.
So you don't have any travel receipts available to you for any travel that you did with Ms. Willis?
I don't have any receipts, no, ma'am.
No receipts that, so you used your business credit card for these trips, correct?
I use my business credit card for everything.
Okay, yes. You used it for your kids' tuition.
Yes, ma'am.
Used it for personal travel with Ms. Willis.
Yes, ma'am.
And you have receipts from those business credit cards that you have to file with your taxes, correct?
No, ma'am.
No.
I filed a statement. I turn over the statement, and whatever's there on the statement, the accountant looks at it. And the accountant says,
like this
okay,
is like,
this
come
is
on,
personal,
this is
goes
obvious.
over here,
He's
this
being
is
shifty
business,
here.
goes over here. Here are your taxes.
So you have those statements. We'll call them statements instead of receipts. You have those statements, correct?
I have the statement, yes, ma'am.
But when you answered the interrogatory under oath, you said you did not have anything to show the records of travel with Ms. Willis.
I answered the question. I had no receipts, ma'am.
You had no receipts, but you had statements.
I ordered the statement, yes, ma'am.
You did order the statement. Okay. And so we're just talking the semantics between invoice and statements or receipt. I'm sorry.
This is Amber Heard again.
Argumentative tone.
I donated it.
And ask me answers.
But I really did donate it.
Let's see. You also in this affidavit said that no funds paid to you for compensation as your role as special counsel was shared with Willis, correct?
That's correct.
And that you never cohabitated with Willis, correct?
That's correct.
By cohabitation, does that mean that you never spent the night with Willis?
I spent the night with her during travel. Yes, ma'am.
Okay. And so I just want to qualify your use of the term cohabitation. That means you didn't live together.
That's correct.
But you did spend the night together.
Yes.
When was the first time you spent the night together?
Your Honor.
That's the subject of his affidavit, Judge.
Right, but it might not be the subject of this hearing. So the question is the nature and extent of the relationship. And so if they just spent the night on a single occasion, I don't think we're going to document in detail every single time that happens.
And I don't intend to do that, Judge, but I think what is relevant is when the relationship started. And that's what you had indicated on.
Well, why don't we start with that question and go from there?
And that's what I asked when the first time he spent the night. That's what I asked.
That's a different question, isn't it?
Yeah, that's a different question.
Okay, so
when the
let's not talk about when you spent the night. When did your romantic relationship with Miss Willis begin?
This is the question. It's the $1 million question.
2022.
When? In 2022.
Early 2022.
So you were appointed in November of 2021.
Yes, ma'am.
And your relationship started early. What's early? January? February?
Around March.
Around March. But you two met at an October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to teach a course, if you will, to newer judges. I did that in 2019. As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing, talking to her at the time was then Judge Willis. She introduced us at that time. We shook hands, exchanged business cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
Okay. When was the next time you talked to her?
Didn't talk to her again, probably maybe a month or a month and a half had gone by.
Okay. So you talked to her November maybe?
Maybe.
On the phone?
On the phone.
Okay. How regularly did you speak with her in 2021 on the phone?
In 2021?
I'm sorry, 2019. I'm so sorry. 2019. How frequently did you speak with her on the phone?
2019, after the meeting, I probably talked to her 2 or 3 times. She would have questions.
Put a 1 in the chat if you think he's full of crap. I think this is bullshit. I think he's lying to his team.
The particular district that I sat in.
Okay.
And the judges would, when they would have questions, they sometimes would go to the rep. So she was outside of my district, but she would call me. She felt comfortable calling me to ask me the questions. I don't know if you know the racial makeup of certain benches, but it wasn't very diverse. So she felt comfortable calling me.
Thank you. So it's just not me.
And she did that. And we had also in common that she was starting a private law practice at the time, and I'd already had mine up and going, and we talked about balancing the demands of the bench with that private practice. So we didn't talk that often, but when she had questions, mostly legal issues that would come up, she would call me.
I just want to make sure, because my question was just how many times, and you said 2 to 3 times, right? Okay. And in 2022, how frequently did you speak in 2022? This is before you were appointed.
I'm sorry, perhaps as much as your timeline, 2022.
I'm sorry, 2020. 2020. How frequently did you speak in 2020?
2020, it was more frequent than 19, obviously, but
More frequent. Can you tell me approximately a month how often you think you spoke with her on the phone?
Your Honor, I'm going to object to the granular detail. I think Mr. Wade can certainly answer however he wants to, but if we're going to go through every time they spoke on the phone as opposed to generally characterizing the relationship, it would be more detailed than is necessary.
Judge, I'm not going to go through every time they spoke on the phone. I'm asking for generally how frequently they spoke.
I think at that level, that's fine.
Thank you. About how frequently did you speak in 2020?
Per month?
I mean, if it was 2 or 3 times that entire year, you can tell me that. If it was more than that, then you can quantify it by month.
No. We spoke on the telephone often. I mean, I don't know how many. I couldn't give you a amount of time because you remember COVID happened and the world was shut down. But so we spoke on the phone more than 2019, definitely.
Okay, let's qualify it. Before her election in 2020, how frequently did you speak?
You mean as she was campaigning?
Before the election. Yes, as she was campaigning, before she was elected.
It's 2 different animals.
As she was campaigning before she was elected.
Okay, so during the course of her campaign, we didn't talk as much, obviously, because she was busy. Fulton County is a large jurisdiction to cover. So we didn't talk a whole lot, but she did know that I'd gone through the election process. So when things would come up that she had questions about, she would call me and ask me. So,
and just to be fair, I'm only Judge, actually, he's not asked and answered. And I mean, I don't mind him explaining, but I just wanted to know how many times. I mean, if we talk about every conversation they talked about, you gotta
let him finish his sentence, and then if you need to redirect him or have me direct him, I can. Mr. Wade, you can continue.
Yes. So sometimes it would be like a 3-second call. She would go, during your election, have you ever seen this? And I would say, no, but here's what I would do. And we'd hang up. She had a lot of professionals working for her, but she trusted my judgment, so she called me. Be brief conversation, but she called.
So my question was, how frequently did you speak with her prior to her election? Frequently? Infrequently?
More than 2019, but it wasn't a everyday thing, no.
In 2021, before you were appointed in November, so January to November 2021, the only time I'm talking about, how frequently did you speak with Ms. Willis on the phone?
In 2021, then it became frequent.
Frequent?
Yes.
But you did not work at the DA's office at that point, correct?
I did not.
So the affidavit that you submitted, you showed on it, you submitted one record that showed that Ms. Willis had paid a couple $100s for one flight, correct?
Say again?
The affidavit that you submitted to this court showed that Ms. Willis had paid for one flight several $100s. Is that correct?
No, ma'am. I think that, are you drawing a distinction for her paying for a flight or for her actually booking a flight? Because those are two separate things.
I will re-ask it. The affidavit you filed in this court, you alleged that Ms. Willis paid for one flight. Paid for one flight, correct?
No, ma'am.
You did not allege she paid for one flight.
No, ma'am. What I allege is that our travel was split roughly evenly. So where you see I have booked the flight or I've paid for a flight with my credit card, what you don't see is that she covered her own flight reimbursement to me. The flights that
now she paid him back for all the trips.
She would have booked
all that stuff. Okay.
With her own car.
And there's one flight, correct?
Oh.
One
this
flight
is full of crap.
reflecting that she actually booked.
Ms. Merchant, let him finish and then you can redirect him.
One flight that she actually booked, yes. The other flights I booked, she paid for.
So the affidavit, you submitted one flight that she booked and paid for.
Yes, ma'am.
Your Honor, I'm going to object to the phrasing of that question. The line in the affidavit is not as Ms. Merchant is representing it. It said examples of the District Attorney Willis purchasing plane tickets for she and I with her personal funds were attached as an exhibit. It certainly did not represent that it was the only example of the District Attorney purchasing flights for Mr. Wade or for compensating other travel.
All right, understand this, Cross. I think that's something you can, it's now on the record, but also something you can take on Cross.
Thank you. And just so everybody is clear, all I asked you is your affidavit, you submitted proof of one flight that she paid for in booked. That's all I'm asking. Correct?
With the explanation, yes, ma'am.
He's like pulling teeth here. He don't want to give nothing up.
You said
He's
in the
trouble.
affidavit that you roughly shared travel though, correct?
Yes, ma'am.
Okay. So this roughly sharing travel, you're saying she reimbursed you.
She did.
And where did you deposit the money she reimbursed you?
Oh, it was cash. She didn't give me any checks.
Oh, of course. Of course.
Mr. Schaefer, you'll step out if you do that again.
Yes, ma'am.
Everybody knows this
So
BS.
all of the vacations that she took, she paid
She
you cash.
paid him back in cash.
Yes,
Oh, how
And you
convenient.
purchased all of these vacations on your business credit card, correct?
Yes, ma'am.
He paid for the card.
And
She
you
pays in
included
cash.
those in deductions
Yeah,
on your
yeah.
taxes, correct?
No, ma'am.
No, you did not.
No, ma'am.
Okay. We'll get to that in just a minute.
Am I the only one who
Let's
thinks
see.
this is obviously he's lying? Is it just that obvious to me? Like this is all
actual
BS.
documentary proof, not
This
cash.
is like
one receipt
obvious
you attached
here
to the
now.
affidavit. Is that correct?
Your Honor, I object to that question. That is a mischaracterization of the assertion that is in the affidavit.
I'm asking.
So then he can deny it. I think he can
I just want to be clear.
fend for himself.
It is my opinion that
the
Nathan
only
Wade is lying
written
through his
proof that
teeth
you have
with this whole
of a
she
trip
paid
she
me
paid
with cash.
That I have?
Yes.
Yes, ma'am.
Okay. So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me, what other receipts do you have then that show that she paid for things?
I don't have them.
Okay. So this is the only receipt that you have to show that she paid for travel.
That I have. Yes, ma'am.
Thank you. Okay. In your divorce,
What does
case,
Bond
you
from
filed
Viva and Bond
a
say?
domestic
Always in
relations
cash, right?
Financial affidavit, correct?
Yes, ma'am.
The first one you filed was in January 2022, right?
Thereabout. Yes, ma'am.
And those are under oath?
Yes.
And you also filed corporate taxes in 2022, correct?
Did.
And tell me about your business. Do you have a partnership or are you a solo practitioner?
As it stands today?
Yes.
So today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income, and we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses, we share income.
Are you registered with the state of Georgia as a partnership?
So the WBC firm that included myself, Terrence Bradley, and Christopher Campbell, we were registered with the Secretary of State as a partnership for a short period of time. When
that was dissolved, though, right, in 2023?
I'm going to object to the witness to answer his question.
Mr. Wade, do you have something else to add there?
I did. When things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella, sharing expenses and income.
Okay. So let me just narrow down my questions then. Are you registered? And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no ma'am.
You've never been registered as a partnership?
As Wade and Campbell, no ma'am.
Wade and Campbell, yes, thank you.
But as Wade Bradley Campbell, yes ma'am.
Wade Bradley Campbell was registered on April 1st, 2021 and administratively dissolved on September 8th, 2023, correct?
Yes ma'am.
Other than that partnership, you have always been registered as law office of Nathan Wade?
Yes ma'am.
Not with Chris Campbell?
Correct.
Thank you. So the affidavit that you filed in your divorce case, the first one in 2022, I think I'm up to number 7. I'm going to just give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking the credit card statements as 9 and your taxes as 10.
I object to taxes, first the relevance of them at this point. The relevance of this entire business structure doesn't seem clear to me as either impeaching or relevant to the issues that the courts, under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't tried to tender them yet, Judge. I'm just marking them right now so that everyone can follow.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things, and so I have a right to go into the veracity of this statements. So let's see, 7, 8, sorry, 9. And then 10. All right, so right now I'm just going to show you what I've marked as these exhibits.
Can I see what you're showing?
Oh, yeah, of course. They're all from the USB drive I gave you.
I don't want to hold you up to copy.
No, they're in the drive I gave you. I'm just. Can I approach Judge?
You may.
I'm just showing you what I marked as 7, 8, 9, and 10.
All right.
Just so you have them for your reference as I ask you some questions.
All right.
So, So these are sworn. I'm first going to ask you about the domestic relations financial affidavit. These are sworn. They're filed under oath, correct?
Yes, ma'am.
And the most recent one that you filed was filed on January 26, 2024.
Yes, ma'am.
So a few weeks ago.
Yes, ma'am.
And in that one, you said that you made $9,500 each month, correct?
Yes, ma'am.
You said that in 2022, well, in 2022, in this case alone, isn't it true you were paid $303,000, over $303,000?
I was paid?
Yes, in this case, Fulton County, by Fulton County.
I see where you're going. So.
And Judge, I just asked him to answer the question. If he wants to explain it, I've got no problem with that.
Mr. Wade, just listen to the question asked and just answer the question asked.
In 2022, isn't it true you were paid over $300,000?
No, ma'am, that is not true.
You were not paid over $300,000 by Fulton County.
No, ma'am, I was not.
Okay. How much were you paid in 2022 then?
So what I was beginning to explain was Fulton County wrote a check to my firm.
Okay.
What happens at that point is the checks are then deposited. As you have the bank statements, you see that. And then they are dispersed between the three of us. So there was Mr. Bradley, there was Mr. Wade, and there was Christopher Campbell. A third. So when you ask me if I was paid $300,000, the answer is no. I got a third of that went to my personal firm. Now, once the money was distributed to my personal firm, obviously the expenses come out of that, and I get, at the end of the day, whatever the profit is. So I did not get $300,000. No, ma'am.
And let me just clarify. My question was not, did you put in your pocket $300,000? My question was the law firm of Nathan Wade paid over $300,000 in the year 2022?
Again, a third of that came to the law firm of Nathan Wade.
So you're saying that the law firm of Nathan Wade did not receive checks from Fulton County government over $300,000 in the year 2022?
That's a different question. A third of the $300,000 came to Nathan Wade.
Okay. Again, I'm not asking what went in your pocket. I'm asking, was the law firm of Nathan Wade paid over $300,000 in 2022?
I'm just asking him.
I know, but I think we're dancing around the point there. So final time, Ms. Merchant.
That's fine. I can move on, Judge. Thank you. So you said that they were dispersed amongst all of you, or put into an account with all of you. So it's your testimony that for 2022, every check you received from Fulton County government went into an operating account with you, Bradley, and Campbell.
No. That's not what I testified to. So the Wade, Bradley, and Campbell firm established an account when we decided to purchase a building in 2022. At that point, every piece of income that came into the entity went into that account.
Okay.
And then after expenses were paid, it was split a third, right? Once that was dissolved, then the funds would go into a different account, my account, one of my accounts. And then I would disperse the funds between now Attorney Campbell and myself, one half and one half.
Okay.
Make sense?
It does. Let me be more direct then. So the Synovus operating account that you had for Wade, Bradley, and Campbell.
Yes, ma'am.
The checks from Fulton County from January of 2022 until June 17th, 2022, those checks were deposited in that operating account.
Yes, ma'am.
Starting on July 15th, 2022, the checks you received from Fulton County up until May 26th, 2022, all went into an escrow account that you had at Fifth Third Bank, correct?
No, not all of them.
Not all of them?
Some of them, yes.
So it's your testimony that some of your checks from July 15th, 2022 up until May 26th, 2023 Some of them went into an account outside of Fifth Third Bank.
Your Honor, I'm object to the relevance of the financial transactions.
How much money you made is highly relevant in this case. It's the personal financial business and where the money was. And I mean, it's just a follow up on other things that he's testified to.
And why is how much money he made relevant?
Because he represented it's very relevant. He filed an affidavit with the court saying, with another court, he told another judge that he made $9,500 a month. That's what he swore to. And
all right, so this entire inquiry is just to establish that prior and consistent statement.
yes.
All right. I'll give you a minute or two more to try that, but we're
Great.
gonna have to move on.
Thank you. So I know you're saying that you only got a third of the $300,000, but you were paid over, the firm was paid over $300,000 in 2022, correct?
So, Ms. Merchant, it's not what I'm saying. They're numbers. They're there. It's the truth. The funds were paid. They were divvied between the three of us, going into an operating account. Expenses paid out of it.
Okay.
At the end of that, the 9,000 figure is what you have.
So that's where you got the 9,000 figure from.
Yes, ma'am.
And let's see, prior to when you filed for divorce in November 2021, you would use Mr. Bradley's credit card to pay for things with Ms. Willis, correct? And then pay him back in cash.
I've never used Mr. Bradley's credit card.
You've never used his credit card
Never.
for transactions to anything with Ms. Willis, out to dinner, anything like that? Hotels?
I've never used Mr. Bradley's credit card. I've never used anyone else's credit card. Not even my father's, and we have the same name.
And you'd pay back, if you ever did use someone's credit card, you'd pay back in cash, is that correct?
Ma'am, I've never used someone else's credit card.
Can you take a look at the bank records that I gave you? That's the largest tab you have.
For the record, which exhibit is this?
It is exhibit, hold on, Judge. Exhibit 9.
Yes, hell, I'm going to say it. This is the top
It should be
prosecutor.
the largest section.
My God.
Your Honor, before there starts three questions from the exhibits haven't been tendered, and I maintain my relevance objection.
All right, let's see what the next question is, and maybe then the objection is going to be highly relevant.
Okay.
Is that an accurate copy of your Capital One statements that you provided in discovery to, is that an accurate reflection of your Capital One records?
That I provided in discovery to whom?
To your divorce lawyers, or that you provided in the divorce proceeding?
Is the question, does he recognize it by sight?
I'm asking if it's his statements, his bank
I
statement.
think that is the question.
Well, I mean, it's a thick document, but I believe you if you say that this is what my wife's divorce lawyer gave you. I believe it.
Your name's on every page of that document, correct?
On every page?
Pretty much every page, if not every page.
No, it's not on every page, no ma'am.
They're all Capital One bank records
They
showing.
are.
Okay. Just take your time, look through it. Tell me if there's anything that you think is not yours.
No, they appear to be.
Okay. And those bank records show that you paid for travel with Miss Willis.
Yes, ma'am.
Your Honor, I'm going to object the relevance of these documents and the.
Well, I think, are you tendering exhibit 9?
I'm going to, Judge, and they're highly relevant to the whole
Well, you've
reason.
asked him a question about the contents of them, and they haven't been admitted yet. So why don't we start there?
Thanks. Those show travel that you and Miss Willis took.
Well, so you're asking about the contents of something that hasn't been admitted yet, right?
Well, I'm asking him if that's what it shows because I know that they're going to object on relevance.
Well, first we got to say if it's you've authenticated it, perhaps.
Yeah, you got to authenticate the
And
document.
before we get
first
into
before you
other details of what's in it, I think
I can
it needs
tender
to be
them. That's
admitted.
fine. I move to admit them.
All right.
Object on relevance.
Is this a
Unrelevant.
fair and accurate representation?
All right.
of
And on that, overrule.
Not just
Ms. Merchant.
words.
Thank you. Those records demonstrate that you paid for travel with yourself and Miss Willis, correct?
They should.
Okay. And let's just talk about that travel.
Okay.
The first trip is Belize in March 2023. Is that a trip that you took with Miss Willis?
Are you asking?
Did you take a trip with Miss Willis in 2023 to Belize?
I did.
Did you take a trip to California with Miss Willis in 2023?
I did.
Did you pay for those trips on that credit card?
I used the credit card to book the travel, but understand.
She paid you back cash.
Well, let me say this. Let's take the Belize trip, for example, since you started there. That was a birthday gift to me, so I paid nothing for that trip. Zero.
Okay. So the charges that are on your card, she gave you cash for?
She did.
Okay. So all of the charges.
Excuse me, Your Honor, I believe the witness had finished answering the question.
Oh, did you have more?
I did.
Okay.
I wanted to get into the charges on the card because so traveling with her is a task. You can probably imagine the attention that happens. So for safety reasons, she would limit her transactions. I mean, imagine trying to walk through an airport or sit at a restaurant or do anything. So there's no attempt to conceal. It's a credit card. Everything is here. So.
And that's not what I asked.
Okay.
What I asked was
the
charges for Belize in March 2023 on that credit card. Those are things you purchased to go with Miss Willis to Belize.
Those are things that we booked with my card that she paid. Yes.
Yes. So those show up on your credit card.
They do.
And you're saying that she paid you cash to reimburse you for all of that.
She did.
And she paid you cash for both of your portions or just hers?
Both.
Okay. So that trip, Belize, just Belize, she paid you for everything on Belize.
The entire trip.
Okay. So the food, tattoo parlor, all that stuff, she paid for.
I'm gonna.
Does anyone in the chat believe
there was no tattoo
believe
parlor in Belize?
The charges, there's a tattoo parlor on the charges. I'm not getting into what it was for. I'm just asking if everything that's on that card related to Belize, she paid you back for.
She paid for, yes, ma'am.
Okay. Let's talk about California. In May 2023, you all went to California together.
Yes.
And you booked plane tickets.
Yes.
And her name was on those plane tickets.
They were.
And so I know you said that you were worried about security and things like that, but that wasn't her name. When she traveled, she had to use her name.
Oh, so the plane tickets? Yes, ma'am.
Mm-hmm. Okay. And you paid for those plane tickets and you paid for a hotel.
So again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
We
were in Napa.
And you're saying that are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip or did she pay for her half of the trip?
The Napa trip?
Mm-hmm.
She paid for the excursions. So the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when I would say, hey, I bought dinner. Dinner cost $25. You need to give me $25.
Okay.
If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I'd object.
So she's going to
overruled, Mr. Wade.
So she's going to insist that she carries her own weight, and it actually was a point of contention between the two of us. She is going to pay her own way.
So let me re-ask the question to make sure that you answer it. A California trip that you paid for, saying that she did not pay you back for cash. Instead, she paid for excursions, and you believe that was roughly half.
No, she gave me some cash, yes.
She
but
gave you
what I'm
some.
saying is the everything that we did when we got into Napa, she paid for.
The trip that she booked on her credit card in Miami, did you pay her cash back for your half of that?
No.
So you never paid her back for the ticket she bought for you?
No. I would say I did pay her back because there were times when I would pay for dinner.
Okay.
She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for, which is why I said that it was a point of contention because she was very emphatic and adamant about this independent, strong woman thing. So she demanded that she pay her own way.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. Let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023.
You booked a trip for $1,481.54.
Are you asking me, did I take that trip with Miss Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee?
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
If he's going to be asked about a particular transaction, then
You can answer whether he remembers or not.
That more, you can see. Something's up with that cabin.
Mr. Wade, I'm not asking you to go through 1,000 pages.
You would know if you were in a cabin in Tennessee.
Paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
That's a yes, people. That's a long yes, but it's a yes.
No.
You've never gone to a cabin with Miss Willis?
No.
Have you ever gone to Tennessee with Miss Willis?
Yes.
Okay. When was that?
Don't
That
tell me it's about the
was-
time you had the cabin.
Around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay. So you didn't spend the night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back.
That's
the reason we would do that is because the attention, she couldn't get any peace of mind going locally. So we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
Is that when you went to Fani Goat?
I gotta put a poll in the chat.
That's in Georgia.
Do you think this guy's lying? This is crazy.
Going to Fani Goat.
She paid me back. I didn't pay her back, and it's all in cash. Yeah, do you really believe this, people?
Yes.
Okay. Did you ever do these day trips in Georgia?
Do we drive anywhere in Georgia?
Yeah, you were talking about day trips going out.
Here comes the poll because
we're talking about outside of the metro area. Day trips.
Either I'm ridiculously crazy.
The ones that you were, I'm only asking about the ones you were just talking about. Are all of those in Tennessee?
No.
There's no way I
drove to Alabama before.
I don't believe anything right now.
You drove to Alabama?
Let me make sure I put this right here in the chat.
Did you go anywhere in Georgia?
Poll. Create a poll.
North Georgia.
Wade being.
No, I'm going to object. If he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately
Ms.
answer.
Merchant, I think if you don't have the specific details yourself,
There's the
you
poll.
need to start getting into
Is Wade being
specifics or more
truthful?
maybe broadly phrased questions. You can't just be exploring around indefinitely.
Is it fair to say that you've taken so many trips with her, you don't even really remember all the places you've gone?
I like
so
that
many
question.
trips.
You're having trouble remembering going if you went to North Georgia or not.
Well, you're asking me about specific places, and I want to be candid in my responses. So I have to jog my memory because these are places that I have frequented, but not with her. So I want to make certain that if there was ever a time that she accompanied me, that I was candid in that response.
Aruba, October 2022. And I've got business record certificate for these, Judge. Might be a little faster. But did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip there was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
And the second leg after the cruise concluded, D.A. Willis and I went to Aruba. So that was all one trip.
Scrappy.
Okay. So my question was, did you go with D.A. Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
Okay. And you paid for a cruise as well, correct?
That's the cruise I was referencing with D.A. Willis, my mother, and myself.
You may have
Okay, and because there's two cruises,
that.
so let's just talk about the first one.
Okay.
So the first one was that's the one with your mother.
Yes.
And so you introduced D.A. Willis to your mother. That trip, you all took a cruise together, the three of you.
Yes.
After the cruise was done, you and D.A. Willis flew to
Intelligent
Aruba
observer.
together, and your
I
mom
agree.
flew home.
100%.
Yes.
And you paid for all of this
Very
with
good
your credit
observation.
card, on your business credit card.
I did.
And are you saying that Ms. Willis paid you cash back for that?
She did.
I think you're right, Tommy.
No, but let me make this distinction though, because the number that you're looking at reflects the three people
Thanks to all my new members.
on the
Thanks
cruise
so
ship.
much.
There were things that my mother and I did, just the two of us, that D.A. Willis didn't do.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother on those.
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
Judge, may I approach with exhibits 10 and 11? They're both certified business records one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 and 12.
Well, it looks like 94%, 95% of the respondents don't believe he's being truthful out of 1,000 votes. Yeah, I don't think he's being truthful. I think he's being
These are
very,
business
very
records.
untruthful.
Judge, they have the certification, so I moved to admit them.
All right. Defense 11 and 12. Ms. Cross.
Based on Ms. Merchant's representation that they are true and accurate as to the certification that was provided to her, you have no objection.
Again, seeing no other
Well, matter
objection.
of fact, intelligent observer, if you want to jump on, just let me know. I'll send you a link.
So the trip to Aruba alone for you and D.A. Willis was $3,835.26, correct? Just Aruba.
I'm looking for the amount.
Which exhibit? Question about 11 or 12.
This one is 11.
Thanks for becoming a new member.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
Okay. I'm in 11.
This guy read the shit one year.
Can you direct me to where you are in exhibit 11?
But remember, she paid him back in cash, though. He's got paid back in cash for all these elaborate trips all over the place, cruises, wherever he went. She's paying him in cash, so he's got no, because obviously she's carrying around thousands of dollars in cash to reimburse him.
I already asked you about.
And when she pays for it, he doesn't pay her back. He doesn't pay her back anything. Do you think the judge is going to buy this? Like, really?
I blacked out their dates.
Thanks for the super. Thank you for the $10. I appreciate it.
Maybe on. Oh, it's small. It's hard to read. It's very hard to read. So let me ask it this way then. Do you recall paying around $1,269.70 for a Royal Caribbean cruise for you and Miss Willis? You don't remember that?
That amount seems kind of small. I don't.
Oh, it's too small. Too small.
Okay, so you believe it was higher. Okay.
They ballers.
While you were in Aruba, then you bought a Norwegian cruise, right? And that was the New Year's Eve cruise?
While I was in Aruba, no, ma'am.
The credit card documents that were admitted earlier show the purchase date when you were in Aruba, but you don't remember doing that in Aruba?
I didn't purchase a cruise while I was in Aruba. That may be when the cruise company decided to run the invoice, but I didn't purchase a cruise in Aruba, no, ma'am.
Around the time you went to Aruba, you purchased a cruise for Norwegian for you and Miss Willis to take for New Year's, correct?
Before I went to Aruba, yes, ma'am.
And that was roughly $3,387. The cruise to Aruba. I mean, the Norwegian cruise.
So that cruise was with my sisters.
Okay.
And the number that you are seeing would reflect my buying dinner for my sisters and their husbands.
I'm just talking about the cruise, the amount that was paid for the cruise ahead of time when you booked the cruise. I'm just talking about that.
Okay.
That was a little over $3,000.
Yes, ma'am.
Okay. So, and I understand you're saying you paid for other things, but I'm just talking about the cruise amount. Okay. And you paid for a Jeep and you paid for dinner while you were there in Bahamas.
Yes, ma'am.
Okay. That's the one that Miss Willis paid for a flight for, correct?
That's one of the flights she paid for. Yes, ma'am.
Actually, a documented paid for, not cash. I'm talking about a non-cash transaction. That's what she paid for.
You mean the one that I provided the receipt for?
Yes.
Yes, ma'am. That's that.
All the other flights were paid in cash. What did she pay with a card?
So she booked that on her credit card and wasn't worried about, I know you said earlier that you were booking everything because she was worried about people knowing where she was traveling. She didn't have any fears booking that one though, correct?
I'm going to object to the phrasing of that question. Speculate as to what was the motivation of the district attorney. She wants to ask if that was the transaction.
Also speculation. That's a good
Ms. Merchant, I think you can rephrase the question, but I'll sustain it on the current phrasing.
Yeah, speculation.
So she purchased that under her own name, correct?
She did.
Okay. Let's see. So I know we talked a little bit about the seminar where you all met. Isn't it true that you would go to Miss Willis's house in South Fulton County occasionally?
I've never gone to her house in South Fulton County.
You've never gone to her house in South
Fulton? I've never seen her house. The first time I even heard the address of that house was when one of the individuals in the election fraud case somehow doxed it and it got out. That was the first time I'd even seen that address.
But you would go to the East Point condo,
I
correct?
appreciate it, bro.
What East Point condo?
East Point, Hapeville, something like that.
I've never been to East Point with Miss Willis.
You've never gone to a condo in either the East Point or Hapeville area with Miss Willis.
Wait, that's different. I have gone to a condo in Hapeville.
Okay. So Hapeville.
Yes, ma'am.
So you have gone to a condo with Miss Willis in Hapeville.
I have.
He's
you spent the night there.
Never.
Never spent the
Never
night.
spent the night.
Never.
Is that the condo that was rented by Robin Yerde?
Yeah. That's a good point.
I believe it was.
And other members of the DA staff were there as well, correct? Sometimes.
I've never been around other members of the DA staff at a condo in Aikville.
There's never been any security for Ms. Willis?
Not around me.
Did you ever ride with Ms. Willis with her security detail to and from the house?
No.
You served on Ms. Willis's transition team, correct?
Yes.
And you were part of all of her interviews where she interviewed and re-interviewed employees?
I would say probably 98, 99% of them, yes.
Is it fair to say you took an active role in these interviews?
Yes, ma'am.
Prior to this, you'd never worked in a DA's office,
welcome,
right?
welcome.
Have I ever worked in her DA's office?
At
No,
a
ma'am.
DA's office, any DA's office?
No, ma'am.
Have you ever managed a large law firm or a
Your
large?
Honor, I'm going to object to the relevance of these questions.
Ms. Merchant?
He served on her transition
Yeah.
team, and so,
Oh.
I mean, what we're trying to prove is that there's a personal and financial relationship, and that it was improper. And so, you know, whether or not
trying to
he
pay
had
back.
experience to serve on this transition team, I think is relevant.
Right. I think I already said that we don't need the evidentiary
Okay.
hearing on that point.
I'll
So
move on.
it's the same.
Yeah,
Um,
right. I think let him talk.
Terrence
as much, 'cause now
Bradley
he's
also
doing the
received
Ahern,
a contract for
donated
Fulton County,
versus
correct?
pledged.
Correct?
You're asking me about Terrence?
I asked if Terrence Bradley also received a contract for Fulton County.
I believe that he did.
And you were partners with him at that time, correct?
I was.
So under what you testified to earlier, you would get a third of that contract as well, correct?
I would have.
And Chris Campbell also had a contract with Fulton County.
I believe he
He's a
did.
third of that too.
And so under what you've testified to, you would also get a third of that, correct?
I would.
They both had contracts for what are called first appearance, which is where they would appear on behalf of the district attorney to do first appearance hearings, correct?
Mhm.
I believe they did.
Okay. And they
yeah.
also had what's called a taint contract. They both entered into them January 25th, 2021, correct?
Filter, yes, ma'am.
Taint or filter.
Yes, ma'am.
He's going-
And
yeah.
that was for work in the anti-corruption unit.
I don't know that it was anti-corruption. I think that it was civil rights, maybe.
And Judge, the DA's or Fulton County's come and I guess brought a certificate now. So we would move to admit the contracts. I've got those. Under that certificate, I was planning on doing it under the open records officer, but I believe now they've certified it. I just haven't looked at everything they've certified though, so.
I'm going to ask that the document be looked at and confirmed prior to its sending.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on his direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those and then not much.
Can we do the not much?
Hmm?
We'll do the not much, and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this
Yeah,
taint
it looks like she's losing
contract,
his case right now, but
and
again,
we're
only
not
heard from one
admitting these
side.
right
We
now,
haven't
but if
heard
I
the other
represent
side,
to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time though, correct?
Oh, absolutely.
Okay, and so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay, so the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes,
Asked
ma'am.
and answered, yeah. I believe they asked and answered you.
You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13.
She's flowing.
Marking that as number 13. May I approach, Judge?
You're right.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the.
He thinks this is going well. It's not going well for him. This is not going well for him.
And this basically says you can't talk about anything that happens inside of the DA's office, right?
This whole she paid me back everything with cash is not going. I don't think it's, if the news is correct, it's not going to go well over the nightly news.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit?
I am, yes. We would tender 13.
Ms. Cross.
Fail to see the relevance or the relevance objection, but otherwise.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this. I also think
How?
Yeah, why? Gotta give me
that
why.
because it's motivation in his testimony. I mean, whether or not he's going to testify to something.
What?
It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Fine. That
Sure, but
agreement doesn't.
he hasn't said that it's
Yeah.
preventing him from testifying in any way today, is it?
Well, and I can ask him about that.
Yeah, Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay. All right. That's fine.
Yeah, so that was a big bowl of nothing.
The contract judge and the invoices that I wanted to admit, I wanted to admit all of his invoices and contracts with Fulton County. I have them certified. I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, they haven't had, I don't think they've had a chance to look at them. So is that's the sole remaining exhibit in line of questioning here?
Yes.
And
so if it's looking like a duck,
in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize them.
But assuming they're admitted, would there actually be anything substantive?
Yeah. Why are you admitting these documents?
All right.
So why are we admitting documents?
Okay. So subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you.
So that's what
Is
the
it
judge is
possible actually
saying.
we take a quick break?
We're getting there.
Okay.
Yeah, the judge wants to just on lunch too. But so I understand. Let's just get it right. What the judge is doing. The judge is saying,
I
listen,
have the opportunity over lunch.
I'm not trying to hear all the BS. If you're not putting stuff in that's not relevant, just don't give it to me. Right? You don't need to pad your case.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship with Miss Willis in social settings?
No, I heard the question. I just need to understand what you're asking me. Like what relationship when
your personal relationship with Miss Willis, unqualified, I'm sorry. Did you discuss your personal relationship, your private, personal, romantic relationship with Miss Willis in social settings?
No, ma'am.
You've never discussed it in social settings?
No, ma'am.
Did you ever discuss it in front of Robin Yurdy in a non-social setting?
No, ma'am. Miss Willis is a very
private person.
As am I. We're private people. Not
a private person.
Our relationship wasn't a secret. It was just private. So no, not at all. I wouldn't have discussed my relationship with Miss Yurdy or anyone else publicly.
Okay. I actually did have some questions just about the invoices. If we want to just.
These are the documents that you're referring to.
Yeah, they are. It's all of his invoices. I mean,
what kind of questions would these be other than the invoices say what they say?
It just that yes, that they say what they say.
All right.
Just talk about them. That's fine. No.
All right.
Thank you.
All right. At this point, we'll take a break. I'll ask the parties to take a look at.
I think they would have done it too. It's a good.
What had you marked that as a defense exhibit?
I have his contracts and his invoices that I'm about to mark. So before he.
All right. So we're going to lunch.
I just want to make sure that the state doesn't have any objections.
So those are marked as.
They're about to be marked.
Go to lunch and then I
Exhibit 14.
Thoughts about this stuff and marking exhibits. So.
All right. So 14 through 18. So I'll ask state take a look at those.
I will take a look at those and see if I can match them up with the certified documents that were.
All right. And then we'll address whether they are tendered for the record when we come back. And from there, then we would turn over to the remainder of defense counsel and then the state for any examination as well. So to that end, let's take 45 minutes. We'll be back at 1 o'clock. Mr. Wade,
1 o'clock.
You're still under oath, and I'd ask you not to speak with any other witnesses about your testimony or about any testimony that's already occurred.
Yes, sir.
All right. We'll be in recess.
We're in recess right now. All right. Let me pause this. All right, so this has been one hell of a morning. This has been one hell of a morning. Let's recap. So, first witness, his lawyer in the defense in the divorce comes up and says, I can't talk about nothing. Not because it's attorney-client privilege, because it's confidential. And because it's confidential, I can't talk about it. So then they went through all that. But then they said, okay, well, we have another witness who was a friend of Fani Willis, who understood the relationship started back in 2019. Now, why is that important? Well, in both court filings that you see today, under oath, Nathan Wade and Fani Willis have both said the relationship started after he started working on the Trump case. That was in 2021. That's when he started. But this witness says, no, it actually started in 2019. How do I know? Because I was friends with her and we would talk about these things and I saw him and her kissing up and all that other stuff. They had a relationship in 2019, 2 years before. Now, they put Wade on the stand and he asked him, well, hold on, when did this relationship start? Because we got all these documents that say you said it started then. He then responds, well, my marriage actually ended in 2015. So when I answered those questions about did you have a relationship with another woman during the marriage, he says, well, me and my wife actually stopped messing with each other in 2015. We didn't officially get divorced until 2021. So between 2015 and 2021, I was doing my own thing. So when I answered that question, did I have relations with other women during the marriage? My response was like, no, because before 2015, I wasn't doing anything. It was only after we got separated, but really didn't separate. And that's what it is. So that was his excuse. So yes, he's saying, yes, the relationship started. I didn't have this physical relationship between us. So that was his first thing. I don't believe him. I believe the relationship started. I think that's all crap, right? If they ask you straight up during the marriage, your marriage is over when you get divorced. His marriage was over. So obviously he was, he was playing a word game there, right? It's really 2015. Now let's go back to the next contention. The next contention was, okay, so now we know your relationship started before that. You said that, she paid that you didn't pay, you paid for all this stuff, but you said you did, right? You said you didn't pay for all this stuff with a girlfriend, but here are all these receipts that said you did. His response to that, is that Fani Willis paid him back for every trip, every meal, every single thing in cash, right? She paid him back in cash. So what does that mean? That means there's no transaction, no record, right? I paid you back in cash. Except for the one time where she paid him back with the card, right? So you see that transaction, but everything else is paid back in cash. What does that mean? That means plane tickets, meals, Ubers, trips on cruises, trips to Belize. All of that was paid back to Wade in cash. And how do we know that's true? From his good word. He's given us his good word that she paid him back in cash. Now, I'm going to say it. I do not believe Fani Willis is breaking off all that cash to give, because we're not talking about just one trip, we're talking about multiple trips, right? Here, there, everywhere, San Francisco, Belize, wherever, cruise ships. And his only response. Now, the reason why he has to say that, he has to say it's all being in cash, right? The reason why, not Venmo, not nothing. Matter of fact, the reason why he's paying these thousands, she's paying him $1,000, is because if it's shown that he paid anything for these trips, these personal trips and everything, being on the payroll like that, that would be the appearance of impropriety, and that would get her thrown off the case. So he has to make it that, hey, I got to pay every single dollar. She's got to pay me back for every single thing. And I have no record of that. So how can I say she paid me back but not have any record of it? Cash. And can you prove she paid me back in cash or not? No, right? You can't prove it, right? You cannot prove it, right? That's why my good friend of the channel, Robert Barnes Viva, always say, always in cash, right? If you don't want the government to know, always in cash. Now, I do not believe Fani Willis is cutting him checks and, giving him all this cash for all these thousands of dollars in trips. I don't believe that. But that's what he is saying. So, as of right now, who do I think is winning? I think the defense here. The defense is because they're the ones being prosecuted with the woman Merchant. I think she's winning. I think she's established a couple of things. Number one, she's established that they had a sexual, right, a romantic relationship. Number two, she's established the relationship started before the divorce was over, right? Because remember, he's saying the relationship started because, and the reason why, because he said, remember, we really were divorced in 2015, but just not on paper. He's pulling the Jada Pinkett Smith, right? We were divorced, between us, but we weren't divorced on paper. So that's what he's pulling for that. And then the money, right? She paid me back for everything. There's just no way I can prove it. I think if you're talking about just the appearance, because remember, the judge is here looking for the appearance of impropriety. Is that enough for the appearance of impropriety? What you just heard him say, without hearing anything else, because there's more witnesses that's still got to come. So based on what he says, I think for me personally, there is an appearance of impropriety. It appears to me that they went on these vacations. He paid for it because he's the man. He paid for it and did all this stuff. And this whole credit, she only paid for one thing, but the rest of them is paid in cash. It's just too unbelievable to me. Does it happen? Yes. But to me personally, I just don't believe it. I don't. And his credibility is just what it is. Like, I personally think his credibility is, it's just nonsense. So I'm going to ask you guys in the chat. I'm not going to put up a poll. This is going to be a 1-2. Right now, do you believe Nathan Wade is telling the truth? Nothing but the truth. So help him God on that stand. That's a 1. If you believe he's telling the truth, it's a 1. If you do not believe he's telling the truth, I'm going to start. That's a 2 in the chat. I am putting a 2 right here because I do not believe this man is telling the truth at all. There's some truth to what he's saying, but I don't believe he's telling the truth. And I believe there is an appearance of impropriety based on what I've seen now. Now, there's more to go. There's more to go. And we've only heard one side, so we got to be very careful. We only heard one side of the story. But based on what I've heard right now, I think there's a clear appearance of impropriety. Now, what does that mean? If the judge says, okay, there's an appearance of impropriety, what the hell does that mean? Well, you know what that means? That means, number one, Wade's off the case. Fani's off the case. And if Fani's off the case, that means the whole district attorney's office is off the case. And if the whole district attorney's office is off the case, that means they move the case to another DA's office. And then that other DA's office will then have to reevaluate to see if they're going to prosecute this case. So I don't know what the judge is thinking. The judge is being fair here, but it's just none of this seems good. None of this seems good. Why hire your boyfriend? Number one, he's your boyfriend before he got hired. He's involved in everything. You're cutting him hundreds of thousands of dollars. There's a lot here. There's a lot here. And obviously, as you heard, his lawyer knows that his relationship with Fani started prior to him being hired. That's why the lawyer didn't want to answer those questions, right? That's what the lawyer said. I don't want to answer those questions. I can't answer them, right? I got a reputation to maintain. So I think that lawyer would have had to cop to that. And just like her friend. Now, also, do you guys believe the friend? Because that was Fani Willis' friend. She did get fired. So they did bring that up, that she got fired and she may just have a bone to pick. But why would she come lie? She rented her co-op to Fani. She was just, right? Why would she lie? She said, no, they started dating right after the conference. He's saying, no, they didn't. Who do you believe? Do you believe her or do you believe Wade, the paid in cash? Wade took a number 2 all over the witness stand. He was trying to be careful. 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 I have a question. If they lose, they get kicked off the case, it goes to another DA. Yes. Will they still be able to use all the same evidence? Yes. Yes, they'll still be able to. But the thing is that most of the other DA's offices are Republican. And they all think this is crap. So if it does go to another DA's office, I'm expecting them to drop the charges. So it's one of those things. It's just one of those things. Well, with that said, I'm going to go get some lunch. I may come back afterwards because I have a couple of things I have to do. Well, you know what? Do I leave this stream going? Because obviously this thing is going to be, people are going to lunch. Or do I go get lunch and then come back? Do I start another stream? So I don't know. Should I start another stream? Go eat and start another stream and come back. Big fan of your videos, thoughtful approach, and your breakdown to tough issues. Thank you so much. Thank you. I really appreciate that. But now I'm just trying to figure out because I'm hungry. I'm gonna go get something to eat too. Leave it going. This friend. All right. Yeah. You know what? Some people say new stream. Leave it going. Leave it going. Leave it going. You know what? Yeah. I'll leave it. I'll leave it going. I'm just gonna go downstairs, get something to munch on. Do I want to play this? Let me see what they're playing on this. So they got the court access here. Go lunch both. David is funny. I think this is crazy though. I didn't think this would I thought they would have better excuses. This whole I was really like, if someone says, "Did you cheat while you were married?" and you say no, if you're not divorced, you're still married. I understand what he's saying, but is the judge going to say, "Well, I understand"? Like, he's obviously lying. Cobb County will drop this in a heartbeat. Yeah, I know Cobb County would drop this in a heartbeat. Of course, nobody wants to deal with this. Don't forget this is a kind of the double-edged case where we may have evidence to indict or even get, because she's got an indictment, but this is also, for a Democrat, it's a career maker, right? You got Trump. For Republicans, it's a career killer. So those are things you gotta, if it goes to Republican, I think it's done. I think I can charge it dismissed with prejudice. I'm just being honest. I'm just being honest. So this is crazy. And don't forget, he's making money off all the other attorneys. This is madness. So, but what I'm going to do, I am going to kill this stream because I don't want to just have like all this time of dead air and then come back. And then I'll be back maybe 5 or 10 minutes before 1 o'clock. So if you guys enjoy this commentary, I will be back. Ask the question earlier, did you see it? No, but if you type it again right now, I'll answer it real quick. This is Jonathan Bowling. I've been trying to answer it because sometimes it's tough answering questions when you got that going on, because I'm trying to listen to this, and I'm trying to also be cognizant of the chat and the super chats, because I like to make sure I tackle super chats while stuff is going on. So if I missed your question, Jonathan, please, ask it again. You should have asked it there. Nate is enough to disqualify. I think there is. Because don't forget, you don't have to show the thing. You got to show there was just an appearance of it. This is the walk, quacks, and flies. It may be a duck, right? So I think there's enough here. I think there's enough at this stage, though. But again, we're only hearing one side of the story. After they finish, we're supposed to be saying there's enough, right? Then you hear the other side, and you're like, okay, there's the holes in it, right? So I've heard one side. To me, he's not credible at all. His credibility is zero, essentially. As soon as he said she paid me back in cash for everything, I don't believe anything else he says after that. I'm just being honest with you people. As soon as he said the whole thing about the whole, what was it? As soon as he said the whole crazy stupid thing about what was the thing he said? What did he say? He said this the stupid thing about our marriage really ended in 2015, but we didn't file divorce in 2021. So anything I did in that time frame, I didn't consider it. No, I don't believe that. I don't believe that. I think those are two lawyerly answers. If I'm the judge, I'm saying I just don't find them to be credible. I find the first woman to be credible, even though she might have had some animosity. She remember, she didn't want to be there. Her lawyer fought for her not to testify, and then she testified adversely. She was like, I don't even want to be here. But so I am assuming she told the truth. She sounded to me like she was telling the truth. I don't know. So I will be back. Give me about, what we got? About another 30 minutes. So I'll be back for the 1 o'clock thing. Let's make it happen. Let me turn this down. Okay, so I'm going to see you guys a little bit before 1 o'clock. We got about 29 minutes. I'm going to get something to eat, and I'll be right back. Listen, thanks again. And hopefully you'll come back, and let's do this after lunch. Is Fani going to be questioned? Yes, she will be questioned. But that's what they're now I got to explain this. So before they can call on Fani, they have to lay the foundation for calling it. You can't just have wild speculation out there, right? So as you saw with Wade, they laid the foundation by bringing that other witness and saying, hey, he's lying about all this. That laid the foundation to say, okay, they've got a good faith basis, believe Wade is lying about all this stuff. So now they can call Wade on and say, okay, Wade, here's all the stuff that you've said. How is this truthful? So you see, he's been explaining that. And then on the back end, then now he's laying that foundation. And then that would allow them to now call Fani, say, okay, we want Fani Willis on. Now we got to ask her about all these things. When did the relationship start with you? Blah, blah, blah. So that's how they're doing it. It's like a little chain. One person brings in Wade. Now Wade brings, so that's what they do. So now I got to eat. I will be back. See you guys in about 25 minutes. Talk to you guys soon. Thanks again. And thanks again for all the super chats, all the love. Thank you so much, people. We're coming back. See you in 25.